Taxes বোঝাটা কি?
Yes, call it.
Grateful আছো।
That's the item number. Madam Lordship.
Milord, item number 1 for non-prosecution. Well, this is written instruction from the petitioner.
I'm on behalf of the
petitioner. Does not want to proceed with the application. Any further, sir? You have the written instructions.
Milord,
Instructions. Given by the petitioner to be granted advocate on record, second on record. Application number 1. This is for non-prosecution.
grateful Lord.
Item number 2.
I'm for the petitioner lordship. In the custody lordship, the election commission is retained lordship. Instead of the state of West Bengal lordship.
Item number 3. I appear for the
My Lord, Mr. Debojit Kundu is the learned advocate on record. My Lord, the petitioner is praying for higher scale on account of his getting a master's degree during the course of his employment. That by a reasoned order, my Lord, at page 35 was rejected by the district inspector.
My Lord.
now you should have been saying it was referred to the larger page.
Well, that instruction also I have to take. The larger bench, I don't know. But here, my Lord, the petitioner.
My Lord,
Yeah.
I am for the petitioner conducting advocate right now in court number 11, division bench. So short password, my Lord, very short password, only 5 minutes.
Here, my Lord, the petitioner has relied on 2 judgments which are there at page 36. Yes, one of the Honorable Division Bench.
Great.
Item number 4.
Lordship, I am for the petition. I am led by Mr. Shah.
So I am for the petitioner. I am allowed to appear for virtual. The issue is very short. The expropriation of the subject private land of the petitioner by the school authority, that is the respondent number 9 and 10, without due course of law. The petitioner petitioner's father was the absolute owner of the property along with his uncle, and the petitioner are the ancestral property, is the owner co-owner of the property out of property of his ancestor by way of inheritance. The total land is of 4 bighas. Out of 4 bighas, 82 decimals of land has been unilaterally demarcated and made construction of wall by the school authority, number 9 and 10, without any reference of the petitioner and without any acquisition or whatsoever, and subsequently recorded the school name in the relevant record of right entry. This is the whole exercise has been done clandestinely. The moment the petitioner came to know, the petitioner immediately lodged a complaint to the authority, including all the state respondents. None of the authority has taken steps any further. So my case is covered by the Honorable Supreme Court judgment very recently passed. That is it is came out from our High Court. That is Kolkata Municipal versus Bimola Devi, Bimal Kumar Shaw, that is reported in 2014, wherein 2024, volume 10, SSC 533, wherein it has been categorically held that so far the private land acquisition is concerned, the state is duty bound to follow 7 principles. That right to notice the private person is entitled to, but that has not been done. Number one, right of audience, that has not been done. Right of right of hearing, that has not been done. The state is duty bound to compensate the private person, that has not been done. These are the seven principles. Nothing has been followed and or whatsoever. This is a complete extrajudicial, extra-legal expropriation of the private land of the petitioner. That is why I am seeking the intervention of this Honorable Court to ensure justice.
When your land has been taken.
Lordship, Para 9.
When your land has been taken.
Para 9, I have
When your
stated
land has been taken.
in the year 2025. Lordship, Para 9, I have-
2025.
Yes.
Yes,
Para 9.
paragraph 9.
Paragraph 9, can you see? I have mentioned the exact portion of the land.
No, paragraph 9, you have stated that you are the co-owner. When
Yes.
the construction was made, where have you stated?
Construction has been made, Lordship. In my representation, I have made it.
Where is the, which page is your representation?
At page, Lordship, 44 onwards.
Which paragraph you have stated that when possession was taken? Which paragraph of the representation?
Yes, Lordship, I am showing.
Yes. Please tell me which paragraph you have stated. Where is the record of rights?
Record of rights, Lordship, at page 31 to 42.
No, recent record of rights. Yes, what is your instruction? You are appealing for the state.
There is a school document. The school has constructed a boundary wall also. So here the school is a necessary part of the
School has been made a party.
school is not appearing lordship.
Yes, that's a different thing altogether, but the school has been made a party.
On behalf of the state or not lordship, it's also not there. Even there is no notice for acquisition and
Sub the school
Yes, we have.
Yes.
when they have received. When the school has received,
Day before yesterday.
where is the affidavit
The
service?
affidavit
They can-
service is on the way, Milord. The clerk is bringing, he's coming from a place where there was raining, he's bringing it, Milord. We'll give it. The moment he comes-
tomorrow.
Lordship,
Then
kindly
day after
fix
tomorrow.
it day after tomorrow. Kindly fix it day after tomorrow.
The learned advocate appearing for the petitioner prays for an accommodation to file the affidavit of service. List this matter day after tomorrow.
Grateful.
Yes, next.
Obliged, Milord.
I don't know, 5.
5 for the petitioner lordship. This is with regard to the claim of 3% lordship.
Claim of
This is
three-
additional increment that the petitioner was appointed.
Claim
as
of
the-
3 persons with regard to what?
Yes, with regard to, he was appointed as the headmaster of Boro Naldhondra.
Additional
Additional-
increment.
Additional increment 3%. I have made to the Commissioner of School Education as well as to the DI.
Additional increment. Which paragraph you have stated?
The paragraph number 2 is my appointment letter.
When were you appointed?
7th August 2011.
Appointment 7th of August 2011.
11. And the
7th or 11?
7th August, 7/8/2011.
Letter of appointment dated 7th of August 2011.
11. And
And
Lordship, the
Upgradation,
on 27th July 2009.
upgradation 27/7/2000. Yes, joined 11. That is what I am saying. Joined 11th of August. Yes, where is the representation?
Yes, representation is at page 40, Lordship.
40.
40.
Representation dated. Where is the date?
20th April 2026.
20th April 2026, date of representation. Yes, additional increment, Commissioner of School Education being the third respondent to consider. Yes, sir. Disposed of. Next. Additional increment. What order? 3%. 3% additional increment. এই কটাই চেঞ্জেস হবে। ঠিক আছে, এই 3% additional increment রিপ্রেজেন্টেশন গুলো কনসিডার করবে, আর কিছু মানে করাবে। হ্যাঁ আছে 3% additional increment, তিনটেই চেঞ্জ হচ্ছে, কবে জয়েন হচ্ছে, স্কুলটা কবে আপগ্রেড হচ্ছে, আর রিপ্রেজেন্টেশনের ডেট।
Lordship, for the petitioner, Lordship.
Yes,
Lordship, what
yes.
happened, Lordship? Petitioner is a school teacher, Lordship.
Yes, what do you want?
Lordship's withdrawal of suspension.
Withdrawal of suspension?
Suspension. Lordship, he was arrested on 11 June, Lordship.
So deemed suspension.
No, after that suspension has been done. The two things, deemed suspension, not that. They have suspended on 7 July. He was got a bail, Lordship, on 2nd July. He joined on 4th July. He worked there. They have issued suspension letter and he has received on 13th July, Lordship. And Lordship knows that Justice Bhaskar Bhattacharya's judgment is there, Lordship, which says that it cannot be done because this is no way connected with the school. This is another.
What was the charge?
Lordship, charges, Lordship, 126(2) of BNS, 115(2) of BNS, Lordship, that is, one is simple hurt and one is attempt to murder, 109 he has given, Lordship. But he was a counselor, it's a totally outside the school authority, Lordship.
School has been made a party.
Lordship, everybody has been served. Everybody has been served, including DI.
Yes, what do you say?
My lord, actually, the respondent number 2 is the answering respondent. Was to the board of citizenship.
Yes. Who is appearing for the board? Mr. Ghosh, you are appearing for the board. You are for primary.
No. Secondary board.
Secondary, who is appearing?
My idea, my lord. My learned senior friend can shed some light.
Plus, who can give?
My learned senior friend.
Who appears for West Bengal?
I
Board
don't
of-
know here, who can appear, I don't know.
There who?
I don't know.
There who is appearing? Secondary board?
Total change, Lordship. Lordship knows that. Total changed. Lordship, they have received it on 23rd.
And what I've been informed by Mr. Ghosh that Mr. Oniban Banerjee from this bar used to appear.
Where is he? Has he come? I'm
Lordship,
passing.
I'm just waiting. And Lordship, I've handed over the judgment, Lordship.
Do you have his mobile number, Mr. Vadajaji? Anyone is, please share it with.
Yes,
Mr.
I'm waiting.
Ask your junior whether he can contact him. Yes, pass over next. Yes.
Lordship, next matter for the petitioner is a matter regarding to SIR, Lordship.
SIR.
SIR, Lordship.
Yes.
Kindly see
SIR.
my page 45, Lordship. My
SIR.
appeal number, Lordship. Lordship, kindly mention the month, Lordship, within 3 months, Lordship. The principal bench have passed a several order within 3 months. You have to consider the appeal. My junior is over there, Lordship. If Shita Shah, he'll hand it over the principal bench
দরকার
order.
নেই, এমনি ছেড়ে দিন।
Lordship, kindly fix the month, Lordship. Lordship, kindly fix the month, Lordship.
Disposed of, yes.
Next is also SIR, Lordship. ওদের প্রত্যেকবার 12টা 12:30
Election
করে
form.
এটা রিলস 7, 8 and 9 both are SI lordship.
7, 8 and 9 all SIR matters.
Lordship.
7, 8 and 9 SIR matters disposed of. Next.
Great.
Item number 10.
Yes, 10 who is appearing.
I'm praying for next circuit because service is not complete, Lordship.
What is this matter?
I'm the retired professor of Kochbihar Pancharan Burma University. This issue is regarding the pension, Lordship. My small prayer is considering my representation.
Who will consider? Who will consider?
Lordship, the authority,
Which authority?
the Honorable Vice Chancellor, Kochbihar Pancharan Burma University. Kindly see the page 32.
Yes, who appears for Kuchbihar Panchanan Burma University?
Lordship, I've
Do not
mailed,
know you are appearing
I've
here.
mailed the soft copies also, Lordship.
Kuchbihar Panchanan Burma University.
My lord, directly, my lord, I just consulted.
Mr. Ghosh, you are appearing.
He knows, my lord, who the police is appeared. Huh? Senior advocate Mr. Amalesh Rai had appeared.
Amalesh Rai, I think he told that he will be appearing today.
I have mailed also, Lordship, the soft copies, but the
All right,
postal receipts are not.
The learned advocate appearing for the petitioner submits that the, yes, you are appearing for whom? Yes, the learned advocate appearing for the, you have been served.
Status.
Yes, what is your instruction?
The marginal information will go. Necessary information will come from first.
The learned advocate appearing for the petitioner submits that the university authorities have not yet been served. First, the petitioner is directed to serve a copy of this writ petition upon the unserved respondents and file an affidavit of service on the next date. List this matter before the next available circuit bench. Yes, next.
Item number 11.
11, I'm for the petitioner, your Lordship. Lordship, kindly keep the
On the
matter
prayer
on.
of the learned advocate, list this matter. Yes. Yes.
Lordship, as the service could not be affected on all the respondents, kindly keep the matter on Thursday. By that, in the meantime, the service will be affected on all.
Service will be done.
Service will be affected on.
Yes,
all.
yes. What is this matter?
Lordship, the matter is about the petitioner is a widow lady who is not receiving the pensionary benefits which she was supposed to receive. The matter is pending for
Which
more
is
than
the
1 year.
appropriate respondent?
The appropriate respondent would be the district inspector of school and the treasury officer, your Lordship.
District Inspector of Schools. Yes, Mr. Bhattacharya. DI schools, you can appear. Treasury Officer Jalpaiguri, you can also represent. Pension, please serving a copy.
Yes, your Lordship, I will serve.
Where is your representation?
Representation is annexed.
Pension or family pension?
Family pension, your Lordship. The representation,
Husband was receiving pension.
the husband was receiving pension.
Was
In
receiving
the meantime,
pension.
he died.
When husband died, when?
Husband died in the year 2025.
He retired when?
Lordship.
23rd of May 2025.
Yes, your Lordship.
Teacher of a headmaster.
Yes, headmaster. He retired as a headmaster.
Headmaster of a high school.
High school.
High school.
High school.
Which paragraph you have stated?
Lordship, I have stated paragraph number 4.
Paragraph number 4.
4, your Lordship.
The
No, high school.
the petitioner claims that her husband retired from service on superannuation while serving as a headmaster of a school at Jalpaiguri on May 23, 2015. Sister, the petitioner states that immediately after the retirement, her husband was enjoying the pensionary benefits till his death on January 20, 2025. So stop. The learned advocate appearing for the petitioner submits that after the death of the husband, the petitioner submitted representations before the, where is the representation?
Representation is annexure P5, Your Lordship.
Gram Panchayat, what will the
Oh,
Gram
no, not only the Gram Panchayat, Lordship, but detailed representation was also made before the authorities.
Where?
Annexure P6, page number 22.
22
Yes, Your Lordship.
submitted a representation before various authorities, including the District Inspector of Schools, its primary education, District Inspector of Schools, bracket primary education, and the Director of Treasuries, praying for high school, no, at a primary school. High school, school করে দিন শুধু এ লিখতে হবে না, ঠিক আছে, স্কুল at Jalpaiguri, BFP, free primary school, not high school. কি হলো? Before the District Inspector of Schools, primary education, and the Director of Treasuries. Full stop. The learned advocate submits that in spite of receipt of such representation, no steps have been taken by the respondent authorities till date. Full stop. Mr. Bhattacharya, learned additional government pleader, is present in court and is requested to appear in this matter. Full stop. The learned advocate for the petition is directed to serve a copy of this writ petition upon Mr. Bhattacharya, learned additional government pleader. Full stop. Your appointment is to be regularized, no? Let the appointment of Mr. Bhattacharya, along with a junior of his choice, be regularized by the concerned authority. Full stop. Paragraph. Without entering into the merits of the claim made by the petitioner in the representation dated 5th of August 2025, WPA number such and such, as disposed of by directing the District Inspector of Schools, Primary Education, Jalpaiguri, being the 5th respondent, to consider the prayer of the petitioner for grant of family pension and to dispose of the same by passing a reasoned order. Full stop. If the 5th respondent decides in favor of the the reasoned order shall be communicated to the petitioner as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 5th of August 2025. Full stop. If the decision of the 5th respondent is in favor of the petitioner, consequential steps thereafter shall be taken by the concerned DI and forward the paper immediately thereafter.
Grateful.
Next.
Other side has come, Lordship.
Item number 6, yes. When is your flight, return flight, Mr. Pal?
5.
Yes.
Yeah, I usually appear for the mode of secondary education, but in this matter, I have not received any instruction.
You can see the
Can you-
judgment
can
that
you-
you have handed over,
Can
Lordship.
you take instructions and come back? When?
Give a copy.
Can you take instructions and come back at 2?
I will try.
2? Not 2. 1,
1.
because he has to leave.
I will try.
All right. Mr. Pal, do you have an extra copy?
Yes.
My junior
Please
is
give him a copy. Please even give him the copy of the judgment also.
Lordship.
Item number 12.
Here, the covering letter says that it is scheduled to appear before your lordship on the 29th.
But the A format is given today's date.
But,
It was already served 48 hours.
but Mr. Ghosh, if you are indicating a specific date, can you expect that learned advocate will appear today? What are you doing? Most of the matters this is being done. Not only in this circuit, previous experience is also there. Why are you doing that?
It has been
You are
done.
giving
The-
different dates,
No, no, it
one
has
date
been
here
done
and another date. to
due
the-
to
Because an
inadvertence.
advocate, he will be going through that date.
Well,
Yes, what
it
is this matter?
Well, the matter is slightly urgent because, my lord, this is directed, my lord, against a notice to demolish, my lord, an office, organizational office of a political party. And my lord, notice has been served under the 1962 Act and my lord, I will demonstrate from records that the notice itself, my lord, is absolutely perverted.
Where is the notice?
My lord, kindly,
Preliminary point of maintenance.
my lord,
Where
kindly-
is the notice?
Yes, my lord. It was affixed in the premises. My lord would find the notice at page 25.
25.
25. No, lord, it is not addressed to any specific individual, addressed to all persons concerned. Whereas an application has been submitted before me regarding the encroachment in the public land in the schedule below. Now, what application has been?
No, Mr. Ghosh, you have been directed to show cause.
Yes, we are.
Please appear.
No, we are challenging this because I'll just place Millard. Kindly see Millard, the first line where an application has been submitted before me regarding the encroachment of a public land. Now, what application that has not been served? Only this has been affixed. Now, Millard, kindly see the plot numbers. 161, 162, 166, 167.
Where is the plot number?
Millard, the next page, the schedule.
Oh, yes.
161, 162, 166, 167. RSLR not mentioned. Millard, all these plot numbers, I have Millard annexed the plot informations are Millard recorded in the name of municipality. Now, Millard, unless municipality files a complaint, without a complaint filed by the municipality, in absence of that, how the SDO assumes jurisdiction? Second, Millard, it is a purely targeted exercise. There are at least, Millard, 15 shops on the same line, adjacent to the road, not encroaching upon the road, adjacent to the road. And this notice has been affixed only on the organizational office of a political party. Now, Millard, kindly cease from page 17 onwards. 16, 17, 18, and 19. All those plot numbers recorded in the name of municipality. Out of which one plot is Millard recorded as path. If it is a road, recorded as a road, 1962 Act specifically excludes roads and highways. It is not available for them to exercise jurisdiction under 1962 Act. So upon which plot the office is situated, that has not been ascertained. Even then, Millard, all the plots are recorded in the name of municipality. A municipality has never said that we are not acquiescing to the possession or your possession is illegal. And this is there since 2005. After 11 years, Millard, all of a sudden this exercise. And that also, Millard, absolutely targeted. 15 shops, only the office and notice has been affixed.
Mr. Bhattacharya, where is the information which you have received?
No, that instruction I don't have, but before your lordship goes into that, my lord, I am raising a point of maintenance. My lord, the petitioner here has filed in an individual capacity. The pleading says that he is secretary of a political party, does not say which political party. Then, my lord, if at all, I go by the pleadings, my lord, that building is being used by a political party. So therefore, my lord, the affected entity is the political party. The political party is not there before your lordship. Now, my lord, if we again go by the pleadings, the secretary. Now, secretary of what? Which organization? State, district, whatever. Whether he has been specifically authorized to file this petition on behalf of the political party, no government, my lord. The affidavit is also.
What is the date mentioned in your letter when it is coming up?
29th day after tomorrow.
So I'm keeping it on 29. Please produce the materials on the basis of which you have formed an opinion that there has been, because this show cause notice says that on the basis of the information received by you. So please produce the materials on the basis of which
Today, as what has fallen from your lordship at the outset, there is just a show cause notice. Now, if your lordship kindly comes to the act, which my lord friend has been part of the writ petition.
yes.
My lord. Kindly please, page 28.
No, Mr. Bhattacharya, if you are ready, I will take it up on merits because Once you make some submissions, some observations from me might come.
Milord,
So-
at least Milord, protect us till 29th evening or 30th morning. 30th, at least till 30th afternoon, Milord, protect us so that they don't proceed with
Had
this.
it been a case, my lord, that it was returnable to them?
Because once it goes, Milord, it goes.
As it is not a case, my lord, the state is not ready to. The state is not ready because of this letter, my lord. State is today not able to completely assist your lordship because of the letter which says it is returnable day after tomorrow. So today, my lord, I am objecting to any prayer of intermission.
No, but Mr. Bhattacharya, if you take steps pursuant to this notice, then everything will be become.
My lord, take steps. What step will I take? I put this question to us. First, my lord, has the petitioner or whoever, my lord, has been asked to appear before the subdivision magistrate on 3rd of August at page 25. So before 3rd of August, my lord, no step can be taken up.
Well, let that be recorded. No difficulty.
It is
Milord, I am
there,
not seeking a direction from the court. Let it be recorded.
There is nothing to record, my lord. And next, my lord, what happens? That after section 3(1) notice is issued, there is a notice, my lord, under section 4(1). So he has to come or whoever.
Mr. Bhattacharya, Mr. Ghosh, section 4(1) order has not been passed.
4(1) order has not been passed.
So,
Let them come back, Milord. Milord,
Sure.
will take it up tomorrow, Milord.
Day after tomorrow.
so you have given the date
Day
as
after-
29.
Day after tomorrow, Milord.
You have created this problem.
No, I apologize, Milord. I
And my lord,
apologize.
so kindly keep the maintainability point.
The when this matter is taken up for hearing, Mr. Bhattacharya, on an additional government pleader raises an objection as to the maintainability of this writ petition. So he further submits that in the communication letter, the date of appearance of this matter, the date of enlistment of this matter has been stated to be 29th of July 2026. So he submits that he has not yet received complete instructions in this matter. First up, list this matter on 29th of July 2026.
Let him, yes, sir.
Yes. 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 Land acquired under which statute? Under which statute? 1894. 1894. Act 1. Yes, now what happened?
Land was recorded in my name. Not previously, my lord to find the record of rights. But thereafter, my lord, order passed by Justice Ponnavan and Guide at page 28 onwards. Second page.
Page 28.
Onwards. The operating section at page 29. I think the land and gets appearing for this. The court finds it proper to direct disbursement of these payments and revisit the compensation paid to the petitioner to
No, Mr. How can it be under the 2013 Act? You have said your acquisition is under the Act 1 of 1894. How can it be?
still not declared. Covered is still not declared. Your land was acquired in the year 2008, 2009. That case is of 2008 line.
No, thereafter compensation has been declared.
Your compensation paid as per the old notification, that is factor 1. Your now your
Please show me the compensation which has been. Where is the award?
calculation sheet at page 27. Serial number 9. Resolution. Factor items separated is 1:1. But I am calculating the challenging the calculations. Instead of factor 1:1, it shall be only 2. As per this is the notification.
This was acquired for what purpose? Railways.
For construction of new broadgauge line from Guwahati to Bangalore. Second paragraph. Page 24.
Yes, thereafter, what happened?
Petition under Article 26 came up for hearing before Justice.
Yes.
Justice Rai directed to the respondent, that is the academy special articles directed to revisit the compensation amount. Thereafter, hearing was conducted not hearing not is a model on page 30.
Page?
December.
Yes.
Page 33.
Where is the notification which you are relying upon?
The old notification of 2000.
No, you want which notification to be applied?
The latest notification.
Where is that? Where is that?
Is 36 below instead P6. Can be multiplied by 2. On the calculation sheet, your calculation what I have been paid. Calculation has been made as per factor 1:1.
1.1.
1 point. Instead of 2. On the previous page below, I want to find the notification of 2014. Your state government notification, they have calculated the as per this old notification. That is the losses not otherwise not. The factor has been calculated as per 116 notification.
Where is the law? Please show me.
May place the recent order. Recent order.
Please show me the act first. এই right to fair compensation একটা দিন 2013 একটা 2013 একটা দিন তো
Here it is written that it is noteworthy to mention that as per section 3 of the Act of 2013, the state government would be the appropriate government. Whereas the Act says, section 3, subsection 4, in relation to the
section
3, subsection E, subsection 1,
yes,
in relation to the land for public purpose. This is a public purpose project in more than one state. This is a railway line constructed from one state to the another. The central government, in consultation with the state government or union territory, might not come to the paragraph 5, section 5, 1 in relation to the land acquired for the purpose of the union. This is the Union of India project. As in the specified and notification, the central government is the appropriate government. From the regional order, my lord, they have only stated the state government is the appropriate government.
yes, what do you say?
They have modified the entire act, my lord. My lord, just one moment, lord. My lord, in same moja,
Allow him to exhaust himself. Yes,
in same
yes, yes.
another different in same moja, my lord, different same projects and different petitioners, my lord. They have got the compensation as per factor 2, my lord. The coordinated judgment is there, my lord, based on that compensation has to be paid as per factor 2, my lord. This petitioner is being deprived, my lord. This petitioner is only the one petitioner, they have been paid, my lord, as per factor 1, calculating the old act, my lord. I have annexed all the coordinated by judgment, my lord. My lord, and my lord, there is also a reason order passed in Krishna Dosh, my lord, from page 20 to page 52, my lord. Here the land acquisition collector, my lord, has itself taken a stand that compensation for this instant case will be recalculated by with the multiplication factor 2. But now they cannot take a different stand, my lord.
Yes,
This is
yes.
judgment I would like to place before the factor.
Central Township, he has submitted 3 days continuous after the submission notice on the notice is passed and order for the filing and published. Because he has placed at the 2016 logic, he has suppressed the clarification notice of this 2016 logic.
Please show me the clarification
Your
notification.
I'm not carrying today because the returnable date is 28th, Lordship.
My lord, reports to be filed, my lord, and
Returnable date is 28.
my
Mr. Das, you have mentioned in the letter as to it.
Bunch of repetition filed indicating the same issue that Moza factor should be 2, Lordship. Lordship, without affidavit, this matter is proper adjudication is not possible, Lordship, because he has suppressed the main.
Let them file a report, Mr. Das. It's
Not
that.
Lordship, affidavit is.
My lord, we find from the full data, I only have one copy. My lord, the appropriate government is the central government. Therefore, the central notification has to be followed, my lord.
May I, my lord, with the lordships can leave, my lord. May I, with the lordship. In civil matter, my lord, the honorable coordinate bench, the one matter has been pleased to direct filing of affidavit in opposition. Regarding report, opposition is ready, report and opposition. is ready.
Already, opposition filed, already filed, the matter is pending for the final hearing.
My lord, what my humble prayer is, since it relates to the same place, similar prayers, my lord, may kindly direct affidavit, my lord, then we'll file affidavit within 2 weeks. And then it.
By the railways, not by the state.
State-
No, Lordship,
State
state has filed, Lordship.
State has filed. affidavit.
Who is appealing for the railways?
Railways was supposed to file their.
State has
Alright.
filed, my lord, upon, so I don't think there is any information. in that.
What Papa is the place order.
What order?
Affidavit
Mr.
and-
Das, this is to be decided. Mr. Das, this is to be decided. Who is the appropriate government? Where is the state or the union? If the rail passes the project, the rail line passes through different states, whether the state government or the union government, that has to be decided, Mr. Das. that has to be decided. You may have a very good case. So they have to be given an opportunity. They have to be given an opportunity, Mr. Das.
They already have issued a notification. Milord, that notification should be on the record.
Yes, that another notification we have brought on record.
Mr. Das, I appreciate that, but these points are to be considered. You have filed, Mr. Das. No, they cannot take. I'm with you, but you have filed a petition, stated some points. Are they not entitled to deal with that? After all, you may succeed.
Direction will pass for filing a report.
On affidavit in opposition.
That's
Filing affidavits are ready. My lord. In all the cases, we will file because the same affidavit, my lord, only the names of the petitioner will change. And we have also relied on another notification in that supporting our case. My lord will file affidavits. Kindly grant.
Order passed by Justice.
Phone order 30. আমি জানি না
File an affidavit. That.
Lordship, because state already has filed the opposition, Lordship, that's why
the issue involved. No, the property of the petitioner. The petitioner claims that his property has been utilized for the purpose of construction of new Moinaguri to Jogi Jhopa, new B full stop G full stop line. The compensation amount has been determined. So this acquisition is under the Railways Act. Why?
Not under the Railways. No.
Not under the Railways Act. 2013 Act. The compensation was determined.
84 Act. 84 Act.
1894 Act.
Yes, Lordship.
1894 Act. These factors will not apply.
Lordship, but the
That is why I'm also
No,
confused.
Lordship, but the award and the compensation was paid after the 2013 Act, Lordship.
We'll come.
Then the question is section 24.
Yes, Lordship.
So it's not that it's under 1894 Act, madam. How do you say 1894 Act? Section 24. If the award has been declared, then all proceedings under the 1894 Act will thereafter continue. If the award has not been declared, it's the 2013 Act which will continue. Please see section 24.
Award has been declared, but possibly compensation has not paid.
Award declared.
Award to declare করেছে. We'll come back with the.
Let us come back with the report.
No, affidavit direction.
After the filing of the first petition, Milord. Kindly see the, I'll annex the calculation sheet. Kindly see the calculation sheet, Milord.
বুঝতে হবে না কখন চুপ করতে হবে। তুমি থাকো affidavitটা করে টুক করে বেরিয়ে যাবো।
এটা কি রেল আছে?
হ্যাঁ, রেলের উপরে তো ডাইরেকশন আছে।
এফিডেভিট
হ্যাঁ, রেল লাইন। সুপ্রিয়া টেবিল করে দিয়ে দিয়েছে।
Milord, page 27.
নিয়ে আসো না কেন?
Please see section 24(2). 24(1)(a) and 24(2).
Yes. 24(2) clarifies, my lord.
Then
We will
it
come
cannot
back
be under 1894 Act. If you say 1894 Act, this factor will not come in.
my lord. Possibly I was not able to correctly place, my lord. Acquisition had taken place under the 18.
Initially,
Yes.
it started
Yes.
under the 1894 Act.
My submission was not that this is not applicable, because even, my lord, what lordship has been pleased to point out, even if, my lord, the compensation was declared, if it was not paid
Or possession not
possession
taken.
not given, 13 will act, my lord. That's
So now the all provisions of 2013 Act will.
yes, my lord. Yes.
Milord, let them come back on Wednesday. Milord.
No, we'll come back with affidavit, my lord.
Full stop. From the consolidated cash voucher
prepared in respect of LAP case number 05/2008-09. It prima facie appears to this court that the compensation was determined in accordance with the provisions laid down under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013, more particularly schedule 1 of the said act. Where is the schedule? It is the land acquisition act. Now the right to fair compensation, consider the land acquisition act. More particularly the first schedule appended, first schedule there. First up. The compensation amount was determined by applying the factor 1.1. First up. Mr. Das Lanet, advocate appearing for the petitioner, submits that the applicable factor in the case on hand should be 2.0 in view of the notification of the Ministry of Urban Development, Government of India, dated 9th of February 2016. First up. Paragraph. Par contra, Mr. Bhattacharya, par contra, Ms. Singh, Lanet additional government leader, Lanet junior government advocate, submits that since the land in question is situated within the state of West Bengal, the notification pertaining to the appropriate government would be the state government and not the central government, and the notification dated 9th of February 2016 issued by the central government cannot be applied to the case on hand. Full stop. After hearing the learned advocates for the respective parties, it appears to this court that the issue as to whether the state government or the central government would be the appropriate government in the case of instant acquisition proceeding has to be decided. First up, the applicable notification. Whether the notification within bracket S issued by the central government or the state government with regard to the applicable factor that has to be applied to the case in hand has also to be considered. First up, paragraph, since various, where is the impugned order? By the order dated 24th of April or 21st of June, by the resumed order dated 24th of April 2026, the Special Land Acquisition Officer Kuch Bihar has applied the notification dated
30th of July 2014, issued by the state government, fixing the multiplier 1.00 to 2.00.
Lord, memo number LA 163 of 163 bracket 2.
From which paragraph?
Lord,
No,
page
it's memo
33,
number.
left hand side. Page 33 left hand side.
Left hand bottom, my lord.
Yes, LA 163. No, reasoned order is dated 24th of April.
Yes, my
It
lord.
was communicated by that memo. Yellow, reasoned order date such. তারপরে লিখুন 1.00 to 2.00. So stop. Since various factual and legal issues have been raised in this writ petition, this court feels that such issue can be decided only after exchange of affidavits by the parties. So stop. Let affidavit in opposition be filed by the affidavit or report, Mr. Bhattacharya, report will also do.
Affidavit is ready in one case, my lord. It will take us 10 days to finalize.
Kindly.
Because then they can also, my lord, we will be bringing in,
1 week we will file the affidavit.
we will bring
Let
in one.
affidavit in opposition be filed within a week from date. Full stop. Reply thereto. Affidavit in opposition be filed by the state as well as the Northeast Frontier Railway, by the authorities of the Northeast Frontier Railway, as well as expeditiously as within a week from date. Full stop. Reply thereto, if any, be filed within a week thereafter. Full stop. Parties will be at liberty to mention this matter for inclusion
My lord, only, may I?
under hearing immediately after expiry of the period fixed for exchange of affidavits.
My lord, for union, we need a little more time.
1 week you can do. This is a short issue. Whether it's the appropriate
My
government.
lord, kindly
And
appreciate
the-
to move the railways is a Herculean task. To move a rail is.
Since you are there, it's not a Herculean task.
33 and 34 are similar matters.
20,
33 and 34.
33 and 34.
33, 34.
Who is appearing for the state?
My lord, we'll give
Let
the-
me call in serially. Yes, next. Hey, Mr. Dutt, please take it. Yes,
Affidavit of service, Lord.
yes. Call the next matter.
My lord, I'm for the picture. My lord, I serve the opposite parties, my lord, but the service is not affected yet. My lord, may kindly fix this matter day after tomorrow. In the meantime, my lord, I'll file the affidavit of service. There's a matter of condonation of delay for the appeal.
Matter of condonation or delay of
CGST appeal. my lord. Service.
on the prayer of the learned advocate for the petitioner list this matter on 29th of July 2026. First stop, the petitioner is directed to effect service upon the respondents and file an affidavit of service on the returnable date.
I'm glad.
Yes, next.
My lord, 15 minute I am for the petitioner. My lord, 15 I am for the petitioner. My lord,
Yes.
15. My lord, this matter pertains to transfer of a assistant teacher who is working in a secondary level. My lord, this is the second round of litigation. My lord, first round of litigation. My lord, kindly see the order on page number 26. My lord, I made a transfer application. Honorable Coordinate Bench directed to consider my case in accordance with law. My lord, then the school authority issued the NOC and forward the matter to the DI. Now, my lord, DI on page order is page 28, which is impugned before your lordship. My lord, may I read out the relevant matter order impugned once. My lord, with reference to the above, undersigned would like to inform you that the undersigned and approach nearby school to spare the assistant teacher of the concerned subject on limited days of the week on temporary basis till such time a permanent teacher on the subject joins by this office memo number 772 dated 27th April 2026. However, none of the school have consented for the same. That means nobody is willing teacher. willing teacher is ready to accept that proposal. Accordingly, my prayer has turned out. But this issue categorically dealt by the Honorable Division Bench. My lord, I have annexed that order, page 29. My lord, kindly go through this order. My lord, where my lord, Honorable Division Bench categorically stated whether willing teacher is found or not, that is not the consonance of the government order. Government, everything is there, my lord. And my lord, I am only praying, let the impugned order be set aside and my case be decided in terms of, my lord, that order I have annexed, that FMA 995 of 20. That is my prayer. But everything is clear. It is a guideline for the how to facilitate the single teacher transfer. It has decided by the Honorable Court very recent, and on all the Honorable Court, subject to correction, single bench, recent single bench, I am relying another decision where, my lord, single bench just last week, my lord, decided in terms of, my lord, that's that Rupok Dhua's matter. Specifically, my lord, I am in our page 5, last paragraph, where Honorable Division Bench categorically stated whether willing teacher, there is no averment in that government notification, willing teacher is find out or not. It is the up to the burden up to the DI to find out the willing teacher, and after that, my transfer, if the candidate, if resultant vacancy is created, that should be filled up in accordance with that. That is the ratio of this Rupok Dhua. So I am only praying, let the impugned order be set aside and decide that same by the DI in accordance with Rupok Dhua. That much I am praying.
Yes, what do you say?
My lord, I am appealing for the statement. My lord,
Yes.
if you consider the post title of this case, my lord, the party number 5, my lord, they have made DI of school Barrackport as party.
Yes.
But they are prayer in the prayer portion, my lord, they are asking an instruction from this honorable court against the DI of school Jalpaiguri.
But it is Jalpaiguri. It should be Jalpaiguri, but it is a typographical mistake.
Should be Jalpaiguri.
It should be
It
Jalpaiguri.
be corrected.
That they will correct. What is your submission on merits?
Yes, sir. My lord, at page 19, my lord,
Yes.
we applied for this general transfer, and the petitioner mentioned few schools' name at page 23, man, where it is like to be transferred.
Yes.
After that, my lord, they preferred this writ petition number 23326, and the
Yes.
reason order was passed by Justice Sampadar. And it is mentioned in this order, my lord, the direction that the respondent number 325 shall consider and dispose of a petitioner representation herein as per rules within 3 months from the date of communication. And after this order, my lord, a copy was served upon the respondent number 5, my lord. And at page 28, DI replied, my lord,
Yes.
and he wrote, undersigned would like to inform you that the undersigned had approached nearby schools to spare an assistant teacher of the concerned subject on the limited days of week on temporary basis till such time a permanent teacher on the subject joins right this office memo number this. However, none of the schools have consented for the same, my lord. And my lord, that's why the respondent number 5 rejected the prayer. And my lord, if you consider this prayer, my lord, respondent number 5, DI school Jalpaiguri is helpless.
The division bench has said
Division,
how he is helpless. The division bench has,
yes, my lord, that is true, my lord.
even then he is helpless. After the division bench has said.
On that, my lord, I am waiting for further instructions.
What further instructions? Division bench has said, after that you are saying helpless.
Yes, my lord, he preferred 3 schools.
You have to reconsider in the light of the division bench.
That is
Ashul,
that is
the order of the District Inspector of Schools within bracket SC Jalpaiguri dated 4th of June 2026 is under challenge in this writ petition. Full stop. The petitioner participated in the selection process for the recruitment of assistant teacher in government aided school. Full stop. The pursuant to the recommendation, the petitioner joined Bhattali Kalua Mohan High School on 23rd December 2013. Full stop. The petitioner applied for online transfer.
Not
No.
online, it is
Uh,
offline. It is offline.
At that time, it was suspended.
Yes, yes, yes.
The petitioner applied for transfer, a general transfer before the concerned authority. Full stop. Alleging inaction on the part of the respondent authorities, the petitioner approached this court and a coordinate bench by an order dated 23rd of February 2026 in WPA 233 of 2026 directed the respondent authorities to consider the representation of the petitioner and to dispose of the same by passing a reasoned order. First step. Pursuant to the said direction, the District Inspector of Schools within bracket SE Jalpaiguri rejected the prayer for transfer by the order dated 4th of June 2026 on the ground of non-availability of temporary arrangement of teacher and in the academic interest of the students of the school. Full stop. The learned advocate appearing for the petitioner submits that the ground of rejection cannot be sustained in the in view of the decision of the Honorable Division Bench dated in view of the order passed by the Honorable Division Bench on July 31, 2025 in FMA 995 of 2025 in the case of Rupak Dhua versus the State of West Bengal and others. First paragraph, the learned advocate appearing for the state submits that the respondent authority, after considering the relevant notification, has passed an order rejecting the prayer for transfer, considering the academic interest of the students of the said school where the teacher is presently serving. First paragraph, a more or less identical issue fell for consideration before the Honorable Division Bench in Rupak Dhua within bracket Supra. The Honorable Division Bench, after noticing the provisions laid down in the West Bengal School Service Commission within bracket General Transfer, Transfer on Special Grounds and Reallocation bracket close rules 2015. Held that the said that in the said notification there is no rider that the DI within bracket SE has to make an endeavor to find out any willing teacher of neighboring school, who can man the post temporarily till regular incumbent joins the post. So, the Honorable Division Bench observed that the term within inverted comma willing does not feature in the said notification. So, in the light of the observations, the Honorable Division Bench directed the concerned DI to act in strict consonance with the provisions of the notification dated 3rd of January 2022. First up, the relevant portion of the order passed by the Honorable Division Bench is extracted hereinafter. Page 32 তে থেকে bracket post. So stop. After going through the recent order, after going through the order of the DI within bracket AC dated 4th of June 2026, this court finds that the said respondent was swayed by the fact that there is no availability of a teacher who is willing to serve the school wherein the petitioner is presently serving. Full stop. The ground of rejection, comma, cannot be, the ground of rejection, comma, in the considered view of this court, comma, cannot be sustained in the light of the decision of Rupak Dua within bracket Supra. So, it's a paragraph. For such reason, this court is inclined to interfere with the order of the DI within bracket AC dated 4th of June 2026. To stop, accordingly, the order dated 4th of June 2026 is set aside and quashed. To stop, the DIAC Jalpaiguri being the
Well, it should be corrected. Well, respondent number 5, it should be corrected. I shall
respondent, DIAC Jalpaiguri being the 5th respondent, is directed to consider the application of the petitioner praying for transfer afresh in the light of the observations made herein before, and to bypassing a recent order after affording an opportunity of hearing to the petitioner or his authorized representative, and communicate the recent order to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order. Full stop, paragraph. On the prayer of the learned advocate for the petitioner, leave is granted to the learned advocate on record to correct the designation of the 5th respondent, comma, here and now, full stop.
Well, at only one
Yes.
observation, only one
That-
observation. Well, at only one observation. If the decision,
yes.
if the decision of the DI goes in my favor, all consequential steps shall be taken. Only one.
If the 5th respondent decides in favor of the petitioner, all consequential steps thereafter shall be taken expeditiously.
Extremely
Yes,
good.
next.
Extremely good.
Yes.
Copy not served upon the state authorities, Lordship.
Copy not served. What
Yes,
is this
Lordship.
matter? What are you praying?
Lordship, I am paying service benefit under the careers advancement scheme, Lordship.
You have not served.
Yes, day after tomorrow,
The
Lordship.
learned advocate appearing for the petitioner submits that the copy of the writ petition has not been served. Full stop. Upon the respondents, full stop. Petitioner is directed to serve a copy of this writ petition upon the respondents and file an affidavit of service on the next date. List this matter before the next available. settlement.
Lordship 29,
Yes,
Lordship.
next.
Lordship 29.
This served, yes.
Great.
17 might have possibly,
Division bench.
yes. previous-
Let the matter go. Let the matter, for want of determination, let the matter go out of list. Yes, none appears for the petition at the time of call, no accommodation has been sought. Yes, next.
Item number 18.
18, my lord, on gratuity matter, lordship. Lordship, this is on ROPA 2009 gratuity in area, lordship. Lordship, I couldn't find lordship's order, but I have, this is Vishwajit Basu's order. Make the lordship.
Yes, disposed of. Next.
Grateful, lordship.
Item number 19.
19 similar, lordship.
Yes,
Order is here.
you are for the state. Yes, disposed of. Next.
Item number 20.
20, lordship, it's a single guy, lordship's order only.
Disposed of. Next.
Item number 21.
21.
Yes.
From here for the state.
Yes.
Area concern single.
Disposed of. Next.
22.
Same, single.
Disposed of. Next. Yes.
23.
Same.
Disposed of. Next.
24.
24 revise. 2009. Revise 2009.
Disposed of. Next.
24.
Grateful point.
5.
Yes, 25. Yes.
I'm paying for short passable.
Why in all matters you are paying for Passover? Please move this matter.
Dr. Arjun Chaudhary, appealing before the Supreme Court, Lordship.
You are here.
I have no brief, Lordship.
Yes,
Kindly,
yes.
Lordship, short passable.
My lord was pleased to hear this matter, my lord.
What is this matter?
Here, my lord, the petitioner has made an application saying that at one point of time, the then headmaster of that school had induced him with the saying that he will get a job and had taken money. That job was never given to him. Subsequently, my lord, an inquiry was done by the headmaster, report was filed. A copy of the report was, my lord, handed over to your lordship the other day.
Yes.
Since Mr. Chaudhary was not there, so
Now you have to challenge that order.
Lordship, the matter is going on, Lordship. Kindly,
Maybe.
Lordship. Kindly, Lordship.
You have to challenge. If you are agreed by that order, you have to challenge that order. The
Lordship, time may be brief, Lordship. Short passable, Lordship. I'm praying for short passable only.
please
5
challenge
to
that
10
order.
minutes passable, Lordship. The matter is going on before the
Merits of
Supreme
on
Court,
this
Lordship.
cannot be gone into here.
Lordship, let.
Since the school authority has already passed an order,
Liberty may be granted for filing an exception.
no exception, challenge this.
Lordship.
Not exception. Since the school authority has already passed an order on 10th of April 2026, and a copy of such order has already been supplied to the petitioner, nothing survives to be decided in this writ petition. First of it is accordingly the writ petition stands disposed of. First of it is, however, made clear that the petitioner, that if the petitioner is aggrieved by such decision, it will be open to the petitioner to work out his remedies in accordance. Yes, next.
Item number 26.
Yes. Yes, yes.
This is a case of police in action, my lord.
Police in action. Yes, why are you not acting?
Lordship, it's a
Says in action,
premature writ petition, Lordship.
premature.
Yes, Lordship.
Stage has not yet come to act.
No, Lordship, state has acted, Lordship.
Stage,
State
stage.
has. Yes, yes, Lordship.
Stage has not yet come to act.
No, state
Let me
has.
see what is the stage. Yes.
Actually, my lord, so far the case is concerned, my minor daughter was kidnapped and she was confined in the house of the private respondents and she was molested by the principal accused. Happens to be
What is
juvenile.
the relation between the petitioner and the private respondent?
No relation. My daughter went to the private tuition.
It's the private tutor, private
No,
respondent.
no,
is the, then
My lord, so far the allegation is concerned, my daughter went to the private tuition from where the prime accused kidnapped her and confined her in their own house after taking aid from the rest.
so you have lodged the complaint.
I have lost the complaint.
FIR has not yet been registered.
FIR has been registered.
Then what do you want?
My lord, still now the rest.
The primary grievance of the petitioner is that in spite of an application being made
before the concerned subdivisional officer,
Okay.
the death certificate is yet to
And
be
submission.
issued. The death certificate recording the death of
The mother of the petitioner.
recording the death of the mother of the petitioner is yet to be issued. So, Mr. Bhattacharya, on additional government feeder submits that that requisition has been annexed here.
No, my lord, I
Uh,
have instructions, my lord.
Submits on instruction that the petitioner was directed to produce directed to resubmit certain documents, full stop, paragraph.
And
if-
Lordship, we have already submitted
You have
all the
already
documents.
submitted.
Yes, Your Lordship.
To
we have
stop,
already
faced with such situation, the learned advocate appealing for the petitioner submits that the documents has already been resubmitted when
After I was called before the
was resubmitted immediately
Yes, Your Lordship.
upon being communicated with the directions by the subdivisional officer. First up paragraph, in view thereof, WPA number such and such stands disposed of by directing the subdivisional officer and subdivisional officer Jalpaiguri Sodor being the third respondent to dispose of the application of the petitioner for registration of the death of his or her
His mother.
his mother as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order.
Great.
So stop.
Lordship, affidavit of
একটা
service
line
be-
লিখে দিন, in case the said respondent requires any further document to be submitted by the petitioner, the petitioner shall comply with such request.
Lordship, the affidavit of service be kept in the record.
Taken on record. Yes, I'm coming after 5 minutes.
Grateful, Lordship.
কোথাও তার কাজ সই আছে, সই আছে না, তাও তো উনিও অ্যাডভোকেট আমি রেকর্ড হয়ে যাচ্ছে। Your signature is there in the Bakaladama already. Oh, advocate. Really,
Article 28.
I'm here for the state, your lordship.
I'm for the railway, lordship.
Yes.
Similar matter, lordship.
Kindly see this
compensation not given.
instruction, your lordship.
Land compensation.
Why compensation not given? Land acquired when?
2015.
2015.
15 order. 28.
If I can have my lords for a moment on the.
2015. Are you sure?
Acquisition notice in Sarban 17/11/05. It's not clear.
Then why do you say 2015?
As my client says that.
Look, we have submitted a report to them, lords. This land was acquired in the year
Please
2000.
give me a minute.
Let them consider my representation.
When did you become the owner?
No, land is recorded in my father's name.
That is what I am asking you. When did you become the owner?
Record is not transferred in favor of.
You have inherited from your father. So you must be knowing when
No,
you
my
became the.
father- My father is died. Till now.
That is what I am telling you. So if your father has died, you have inherited. When you inherited, when you became the owner.
Death certificate not annexed, lordship.
You must be knowing when your father died.
I have to take instruction. I have.
What instructions?
I
Lords,
don't
can
know.
have a look at the report that I have submitted to them, lords. This land was acquired in 2004, 2005. Paragraph 2 of the report says that the above mentioned plot.
Mr. Please give me a minute. How do you come to know that the compensation was not paid?
Compensation was paid,
Mr. Mishro, I asked you, please take your seat.
Man.
You have a chair behind you. Please take your seat. Yes, sir. Please tell me, how did you come to know that the compensation amount has not been paid?
My father, land was recorded in my father's name. My father has died long back. I don't know the exact date when my father was died. As far as.
And also you don't know the
as my-
compensation paid or
my
not?
client knows that, but I don't know.
The client also does not know whether the compensation has been. Please allow me to complete. Compensation paid or not?
Not.
What is the source of your knowledge that compensation has not been paid? Please tell me, show me from the writ petition. What is the source of your knowledge that the compensation was not paid to your father?
Lordship, in the page number 23.
Yes.
Acquisition notice in favor of me.
Page
24.
24.
Yes.
Yes.
My name is Toman De. Acquisition notice in favor of me. I am also
Yes.
petitioner.
Yes. This is when?
Acquisition notice served on 2005.
Yes.
This date is not clear in here. My father name is Tarakanto De.
Yes. So you appeared before the authorities.
Yes, 2-3 times I have made the representation. Last representation I annexed.
Yes.
But they are not giving opportunity for hearing.
Yes, Mr. Mishra.
Yes. The learned council members has not been briefed correctly, my lord. If I can have my lordship for a moment on the report that I am submitting, lords, this acquisition pertains to 2004-2005 for a railway project. Paragraph 2 says that the ever mentioned plot of land was acquired from his father, and all the 6 legal heirs, my lords, have been paid the compensation in equal proportion. His amount was 10,484 in the year 16th of February 2006, which was disbursed in his favor.
No, Lordship. I don't have any instruction. No compensation was paid. Let them show them the calculation report.
The calculation is on the second page.
Let them submit the calculation sheet.
The calculation sheet is on the second page, my lords. The name, my lords, Tamal De would appear at serial number 72.
Sir, you are taking a great risk, I'm telling you.
Lordship, I have to take instruction about this.
That is why I asked you these questions. You are taking a great risk. False statement on affidavit.
In this plot number, Lordship, in the other plot, no plot is mentioned here.
On the first page, the
Sir,
plot
I
number.
am putting you on notice.
On the first
I'm
page, the
putting
plot
you on
number is there.
notice. You means your client. So, false statement on affidavit. These are documents. If it is found that it's a false statement on affidavit, consequences, you know, what are the consequences that will follow?
Lordship, I have to take instruction, give me one more accommodation.
Then
Can I take it?
A copy of the report. It is
Sir, it's very easy to say, after taking compensation, making a representation, I have not received.
I have to take instruction about this.
No, your client must be knowing. I'm not saying anything. Your client knows very well.
Maybe I-
Your client knows very well. Even that he has filed a false statement made a false statement on oath.
Here,
That is why I asked you those questions. I asked Mr. Mishra to sit down.
Lordship, and here, no plot is mentioned here.
No, if you still want to pursue with that,
I have to take
I'm
instruction.
keeping it tomorrow. Please come back with instructions. Ashun, the petitioner alleges that though the property of the petitioners have been utilized for the purpose of laying railway tracks, for the purpose of a railway project, but the compensation in respect thereof has not been paid to the petitioners. First up, the report of the Special Land Acquisition Officer, Kuch Bihar, dated 17th of July 2026, filed by Mr. Mishra, Learned Assistant Additional Advocate General, is taken on record. First up, a copy of such report has been supplied to the Learned Advocate for the petitioner. First up, the report specifically states that on 16th of February 2026, 2006, the payment has been made to
serial number 72, my lords, Tamal De.
to
to the petitioner in respect of plot numbers 138, 153 and 154. Full stop. Faced with such situation, the learned advocate appearing for the petitioner prays for a day's accommodation to revert back with necessary instructions. List this matter tomorrow under the heading for orders. No, sir. Tomorrow. You can take instructions because that is there. Tomorrow, please come back with instructions.
Oblige.
Yes. Next.
29.
Yes.
Instruction.
Land acquisition matter. Yes. What is the issue factor?
Reason note, I am challenging the reason note passed by the special land acquisition collector.
Yes. What is the reasoned order?
Petition was taken up by Justice Sinha, my lord. My lord, there was an order directing the special land acquisition collector to consider the prayer of the petitioner, my lord, within the period of.
What is the reasoned order? Please show me that.
My lord, from the reason order, my lord will find from page 23, my lord, the last paragraph.
Yes.
Sri Subhash Bormon on behalf of the petitioner submits.
Page 23.
Page 23, last paragraph.
Yes, yes.
The Sri Subhash Bormon on behalf of the petitioner submits as under that he is the owner of plot number 397399, courtier number such and such, jail number Moja such and such, Alipurduar, measuring about such and such. Lord, thereafter, Lord, on the next page, Lord, that by SO number such and such, stated such and such, and section 3(4) of the National Highways Act have declared to acquire the said plot such and such under Inlet case number. No compensation was paid to him as entitled in acquisition.
No, you want compensation in respect of which plots?
Lord, 397 and 399.
397 and 399. Yes.
Lord, my lord will come below, Lord. Upon perusal of applicable record, my lord, it is seen that SO number such and such, dated such and such, the subject land being plot number 397, 399, under courtier number such and such, dated Moja District, West Bengal, was acquired for the purpose of construction of 4-lane national highway under National Highways Act 1956. Thereafter, by notice number such and such, in lab case number such and such, it was notified that the area acquired in LR plot number 397 is 0.02 acres and LR plot number 397 is 0.10 acres. Thus, the total 0.12 acres. Upon perusal of courtier number such and such recorded in the name of petitioner hearing, in respect to the subject land, it is seen that both LR plot number 397 is 397. The classification is known as hospital. Next paragraph, Lord. The petitioner has submitted written. Interestingly, Lord, kindly marks this paragraph. The petitioner has submitted a written submission dated such and such, wherein he has admitted that plot number 397 and 399, subject plot in the writ petition, is under the possession of the hospital. He states that he will not seek compensation over the plot number of over such plot of the writ petition. Kindly seize the representation which I have made.
Where is that representation?
Page 22, Lord.
Page 20.
From the four corners of the such submission was not at all made at the time of hearing. Nothing of that sort was stated, Lord. Out of his own goodwill, my lord, the reasoned order has been passed, Lord. They are admitting, Lord, that plot has been acquired, no compensation has been paid.
Yes, 397 and 399 is in the name of the hospital you have stated.
So it is the hospital only, and this requisition is filed on behalf of the hospital. Classification is stated as hospital and represented by the manager. Manager is seeking compensation. Sonarpur Samoboy Krishi Unnayan Samiti Limited is a hospital. Milord, and petitioner is represented by its manager. Kindly see the Khotian, I have annexed page.
Mr. Das, that is in your name. That is why if it is in your name, it's in your possession. How will be entitled to compensation in respect of 2 plots?
No, I am not in possession, Milord. I am not in possession.
That is
Milord,
your,
land has been acquired, Milord, from the recent order, my lord, to file.
all plots in my possession except 397 and 399. This plot
Yes,
is in the
that means
possession.
They have acquired it.
Yes, Mr. Miso, what do you say?
Lord, sir, if I can have also for a moment on page 24. At that point of time, Lord, he was not willing to take the compensation because it is a hospital. Today, Milord, if he says that he is willing to take the compensation, we will calculate the compensation. What can we do?
Ashun, the
Kindly records, Milord,
Mr.
and set aside the recent order. Milord.
Mr.
No, there is no question of setting aside the.
Milord,
Then
let us-
he was
how
not
like
interested in
this
compensation.
Mr. Das, please wait. Let the report come. Everything will be clear after that. Don't be so vociferous in land acquisition matters, I'm telling you. Don't be so vociferous. Because I was dealing with this determination for quite some time.
I know.
So please don't be so vociferous. The petitioner has challenged the order of the special order of the Joint Register of Corporate, the Special Land Acquisition Officer Jalpaiguri, dated 18th of June, 2025. Full in the said order, it has been recorded that the petitioner has not sought for compensation over the over plot numbers 397 and 398.
399.
Sorry, 397 and 399. Full stop. Mr. Das, learned advocate appearing for the petitioner, draws the attention of the court to the representation dated 18th of June 2025 in support of his contention that the petitioner has only stated that plot number 397 and 399 is in the possession of the hospital. So he submits that it has not been stated in the said representation that the petitioner has not claimed any compensation in respect of the said 2 plots. Full stop. The learned assistant additional advocate general pressed for some time to revert back with necessary instructions. Full stop. Let a report in the form of an affidavit be filed by the Special Land Acquisition Officer.
Can it be just a report without affidavit? Because what we say is that at the time of hearing, he has given a written submission.
That is why
Well,
I've said report in the form of an affidavit. A report in the form of an affidavit be filed by the Special Land Acquisition Officer,
Number 6.
Jalpaiguri, being the 7th respondent. Within a week,
Thursday, Milord. Thursday, my lord. Kindly, Milord.
he will have to search for the records and then he will.
Milord, everything is before your
Sometime
lordship.
has to be there.
Everything is before your lordship.
Previously,
Nothing
he was
more.
not interested in compensation. Now he is
Milord,
interested.
everything is before your lordship, Milord.
With the
Just
change
a
of
one-page
dispensation,
report
the
will suffice.
mindset is also getting.
Only 1-page report will suffice, Milord. One
acquisition of which year? 2012, 2013.
Yes, Milord.
He
Recent,
can wait for
Current, Milord.
a few more weeks.
Milord, current, Milord.
Report in the 1 week. List this matter before the next available circuit bench, under the heading motion.
Milord, and one
Yes.
thing needs to be clarified, Milord, when it was acquired, it was under the Alipurduar Special Land Acquisition Officer, Milord. Now it has come under the, it was under the Jalpaiguri's land.
Now it has been Alipurduar. Then Alipurduar, I think, will be no.
No,
Mine
no,
is
no.
kind
I think
of-
that
Hearing was done before the Jalpaiguri.
the report should be here. I will.
That officer is still there or he has changed?
No, separate office has been formed in Alipurduar. The old records
The
are here.
person who heard this matter
Is he still there or he has changed?
Lord, I have made both of them party, Lord. Respondent number 6 and respondent number 7.
All right, 6 and 7, let both of them file separate reports. Mr. Mishra, 6 and 7. Yes, next.
30.
30, yes.
For item 30 and 31 pertains to SIR, my lord.
SIR. SIR disposed of next. 31.
31 also.
SIR. 30, 31 SIR disposed of next.
32.
Yes. Land acquisition. What is this?
Milord, CPF to GPF, Milord.
CPF to GPF.
Yes, husband of the petitioner, Milord, was assistant teacher of.
What happened?
Milord, thereafter retired.
They are rejected.
No, Milord. Option opted the option from converting Milord family pension from GPF to CPF to GPF.
What happened? Have you made the prayer? What happened to that? Where is your application? Now we have paid for PPO has been. That is what I have said. Where is your option application? Yes. Yes. What is your instruction? Yes. Yes, yes. What do you say? From the date of refund.
From the date of retirement till the date of.
Yes. CPF to GPF. Order আছে না? Do you have the copy of that order? Tomorrow রেখে দিন. Tomorrow. CPF to GPF. Yes. Yes. 32. Yes. এটাই তো 32 ছিল. Factor 2. What was the earlier matter? That here also 1.1. Same project. Same project. What was the earlier matter? 1.3. Same as 13. Yes, next. 32 and 33. 33 and 34. Same as 13. Yes, call the next matter. Taken on record next.
My lord, item number 35, I beg to appear online.
Yes, 35, yes.
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 My lord, this is the 8th round of litigation seeking transfer. I'm an assistant teacher working at Batashi Shastriji High School.
8th round of litigation?
8th round of litigation. My lord, on the last round of litigation, on several other litigations, I was set at liberty to file a fresh representation seeking transfer. Now, my lords, kindly seize the order passed in the last round of litigation. That's at page number 138 and onwards.
Yes, what is the impugned order?
My lord, I'll indicate. My lord, kindly
38.
seize 138. Kindly seize 138 for once.
138 is an order passed by the court.
Yes, 138 is an order passed by the court. Now, what does they say? Towards the, in page number 139, para number 4 of the order, it says that there is a postgraduate post lying vacant in Shiliguri Jagadish Chandra Vidyapith. Now, my lord, the commission was asked to seek instructions on the same. Page number 140, page number 140, thereafter they come with instructions saying that there are other candidates on medical grounds. Therefore, the application of the petitioner cannot be considered. It is the statement given by the commission. And this order, my lord, the final order in which my matter was disposed of was on 23rd of December 2025. Now, my lord, page number 142, I have procured a document in which, my lord, it reflects that the commission themselves are not sure of what the submissions made before the last writ court. They are seeking report on the same after disposal of the entire matter. Kindly sees the last two paragraphs. My lord, if
It
I
is
may
a very
read,
good ground for review, sir. It is a very good ground for review.
my lord, the only
It is a very
difficulty
good ground
is
for review.
now, my lord, why I have come here? The only difficulty is when I have procured this document, so far as the last order of the last writ petition is considered, is considered, I was set at liberty to file a fresh application for transfer. Now, my lord, I had a word with the commission. They said, no, we will proceed with this. Okay, now you have procured this document. We will proceed on the basis of this. We will try and find out where you rank one and there are no other applicants. This, my lord, this document was issued on 14/1/2026.
Now what
my lord,
happened?
now, my lord, for the last 7 months, my lord, they did not.
Who is for the School Service Commission? Who is for the School Service Commission? Who is appearing there? Mr. Rai? Who is appearing in the School Service Commission before the principal bench?
My lord, I generally appear in on behalf of the School Service Commission, my lord. But in this matter, my lord, I have not received any instruction or brief from the commission, my lord. So,
No,
my lord, I kindly
who are you?
direct the
You are not visible.
my lord.
Oh, Mr. Rai, you are appearing.
Yes, my lord. But
You
my
are
lord, I have not received
right.
any instruction or. My lord,
All right,
I have not received a
serve
copy of the brief. My lord, kindly direct the petitioner to serve a copy of the writ petition upon me, my lord, so that I can
Yes,
take
please
instruction.
serve a copy of the learned advocate for the petitioner is directed to serve a copy of this writ petition upon Mr. Roy, learned advocate, who usually appears for the School Service Commission. Full stop. Yes, Mr. Roy, when can you come back?
My lord, next week, any day, my lord.
Next week?
Any day in the next week.
Full stop, list this matter before the next available circuit bench. Under the heading motion.
Kindly sees if this matter can be
Yes,
taken up anytime next.
He wants next week. Next week, this circuit bench will not be available. Yes, next.
Grateful. Lord, my appearance may be taken on record.
Yes,
I'll
yes,
put
yes.
it in the chat box.
Your appearance is taken. Yes, yes.
Grateful.
Yes, who is for the petitioner?
My lord, I am for the petitioner, my lord, appearing, my lord, online. My lord, this is a case of police high-handedness, my lord. What happened, my lord? I filed a FIR, my lord, against some Bhutanese nationals, my lord. Now, my lord, with Bhutan, my lord, we do not have a reciprocating territory agreement with India. My lord, that's why, my lord, I could not. I am.
Singh, have you received instructions? Yes.
My lord, I am engaged in a gym business, my lord. I set up gyms, my lord. These there are Bhutanese nationals purchase things from me, my lord, to the tune of 1 crore, my lord. Now I have filed a FIR, my lord. Kindly comes to page, my lord. Page 11, my lord. This is an order, my lord. These Bhutanese nationals have, my lord, taken bail, my lord, with the assurance that they will pay me back the rest of the amount, my lord. Kindly comes to page 11, my lord, of the writ petition, my lord. My lord, now comes to paragraph 3, my lord. It is submitted that the petitioner is willing to pay back. My lord, now, my lord, I have, my lord, very next page, my lord, I have, my lord, made my representation or complaint before the Ministry of External Home Affairs, my lord, regarding this, my lord. Now, somebody, my lord, pretending to be a person from Home Affairs, my lord, approached me, my lord. Now, he got arrested on, my lord, probably on 2nd of 2nd of July, my lord. Now, then and there, my lord, at page 17, my lord, my lord will get a email, my lord. I have sent to the PS stating that this person, MHA official, has approached me and my lord held out that he will help me in this matter, my lord. Now he got arrested, my lord. From his arrest, my lord, I am receiving calls from the police station to come, my lord. Police is after my life, my lord, coming day and night at my residence and my shop, my lord, to my lord.
Yes,
and
Mr.
calling
Singh, what
me,
is
my
your
lord.
instruction?
It was lost.
Yes, do one thing, you please file a report. You please file a report.
Acknowledgement. My lord, in the meantime, my lord protects me, my lord.
Stating that one person, namely Jogendra Singh Ranawat, himself as a officer of the Ministry of Home Affairs, and demanded the payment 2 lakhs rupees outside the bond and one say that the outside inspection of the jail and other respondents.
What is the other respondents have not been made a party?
My lord, I don't know about any other respondent, my lord, except police, my lord. Except police, the police is coming day and night at my shop and house, my lord, for reasons best known to them, my lord. They have not issued a 35 notice, neither they have called me by any other notice.
I am the officer of the Home Affairs project. Then we said that because I will settle the case.
My lord, may I interject? I cannot hear a word of my learned friend.
Yes, yes. Yes, please allow her to submit. Yes.
Yes, my lord protects me in the meantime, my lord.
So protection will have to be done after hearing the other side.
Yes,
cannot be a blanket protection. Yes.
My lord, for 7 days, my lord, I can run my business, my lord. I cannot enter the Joygaon, my lord.
That I do not know. What are you doing? That I do not know. Yes.
Ganesh Pradhan has lodged and complained that someone has called him and said that I am an officer of the Ministry of Home Affairs. I will settle your dispute, Lordship. After getting the call, Ganesh Pradhan has lodged and complained before Jaigaon police station stating that someone has called me and asked me 2 lakh rupees for settle the dispute. When the matter was registered, the case was registered, police arrested this Jogendra Singh Ranawat, and in the interrogation, Lordship, it has been pictured that this petitioner Babu Rathi and Jogendra Singh Ranawat, they are clubbing hands and trying to.
My lord, why should I do that? My lord, I have a order for me. Why should I do that? My lord, now the police is coming.
The Babu Rathi and Jogendra Singh meet him 2-3 months ago when he was traveling to Assam by train. Since then, both of them started conspiracy to threaten the opposite party of Jaigaon PS case number 291/2025 dated 11.
Who is the opposite party of that?
Opposite party in the FIR, Lordship.
Yes.
Not
What is the name of that?
opposite party name is
Purno Bahadur Biswas. Yes, please file the report. Letter report.
Ajay Dahal, Lordship.
Letter report be filed by the this is instructions given by whom?
OC Jaigaon, Lordship.
Letter report be filed by the officer in charge, Jaigaon Police Station, being the third respondent with regard to the allegations contained in this petition within a week from date. Full-stop this matter before the.
Mala kindly protects me so
Yes,
that I
next.
can run my business.
No, not at this stage. Yes, next. Yes.
For the petitioner, item number 37, my lord.
Yes.
This petitioner was appointed as Group C staff in a state-aided school situated within the jurisdiction of the Gorkhaland Territorial Administration, my lord. Now, my lord, within the Gorkhaland Territorial Administration area, my lord, there is no applicability of the West Bengal School Service Commission or any other examination. So, my lord, the school committee was compelled to appoint me to run the function of the state school, my lord. Now, my lord, I filed representation to regularize my job there, my lord. Moreover, my lord, on the similarly situated other persons, my lord, those who were working as Group C or
Yes,
Group D
what is
staff-
the instruction?
Lordship, state is not appearing, Lordship.
Who is the state served?
My lord, as per my knowledge, state has been served, my lord.
Who is appearing? Mr. Bhattacharya? Where is Mr. Bhattacharya?
I am appearing on behalf of the GTA, Lordship.
Mr. Bhattacharya, can you appear in this? Because
And my
this is
lord-
also appointment with regard to
Regularization of appointment, my lord.
regularization of appointment.
37 state ki
And my
copy
lord,
service.
Honorable Division Bench has already passed or judgment with regard to this, my lord, and GTA has also acted upon that, my lord.
Lordship, but
If 2 copies are served, my lord, afresh. I'm not saying.
Yes.
this is not-
but
You are
Lordship,
for the
now,
GTA.
yes, Lordship, I am for the GTA, but Lordship, this now this matter cannot be heard without this
Now, what has
Why?
happened? This is appointment of this teacher too.
teacher night, a non.
Coordinate benches also have, my lord, passed judgments with regard to that,
My
my lord.
possibly, I don't have the copy, my lord, but in respect of appointment of voluntary teacher, even though, my lord, there are orders and judgments of this honorable court allowing this. Now, against one order, there is an appeal pending before the division bench here, filed by a third party, my lord, leave to appeal.
Oh, that matters.
Yes, and my lord, the stand of the government today is, as of now, is that these all appointments are illegal, my lord. Because, Lordship, we have come across records where people who have not passed class 8 have been appointed as teacher in high school.
But in my case, it's not that, my lord.
State is also, my lord, in the process of filing appeals against the orders. So,
Our regularization can be done.
My lord, there is judgment, my lord. I have been protected by that judgment, my lord. And similarly,
How were you appointed? What was the process by which you were
my
appointed?
lord, interview. Through interview, I was appointed, my lord.
Open advertisement.
My lord.
Open advertisement. Please show me.
I know.
Pleadings where have you stated?
Well,
Open advertisement. When advertisement was issued? How many candidates participated? When was your interview? Please show me.
My lord, kindly allow me to file supplementary affidavit with regard to that, my lord.
After some argument, the learned advocate appealed for the petitioner, prays for leave to file supplementary affidavit. Full stop paragraph. Let supplementary affidavit be filed by the petitioners within a week.
Within 10 days, my lord.
Within 2 weeks from date. Upon serving a copy of the same to the learned advocate for the GTA and the state. Full stop list this matter before the next available circuit bench. After the period fixed for filing of the, after expiry of the period fixed for filing of the supplementary
my
affidavit.
lord, 2 copies may be served.
Please serve a copy upon lordship. The petition is directed to serve a copy of this writ petition upon Mr. Bhattacharya, learned addition completed
By today, I
in
shall be
course of
serving.
this day.
Yes,
Yes,
affidavit
next.
डालना है ना, उसके ऊपर लिख दो affidavit. Yes, Lordship.
Yes.
Lordship, in item number 38, Lordship, we tried our best to get the instruction, but instruction has not come. But Lordship, there is a.
What is this matter?
My lord, this matter is, the petitioner husband is the employee of
वहाँ
forest
पर 2024 का recommendation है.
He died, but till today, he did not.
To release the family pension.
My lord,
Sister wife.
Dispute between 2 wives.
my lord, it is the.
You are the other wife.
Yes, Lordship. I'm the first wife.
You are the first wife.
My lord, I am the first wife. She is the second wife.
Both are first
File a
wife.
suit for declaration. Who is first, who is second?
Lordship,
How?
I'm the first wife, and as per there is a marriage certificate. 1981 was the marriage date.
What can be done? How this can be decided?
My lord,
Yeah.
my lord, I have submitted the birth certificate of two children.
Yes, who is the appropriate authority? Please consider that.
Yes, Lordship. Chief Conservator of Forest, Lordship.
Chief conservator,
Yes,
which
Lord-
respondent?
Respondent number 6, Lordship.
Six, my lord.
There is a representation in page number, Lordship.
Pagination is not there in my copy, Lordship. 13 December 2024, Lordship.
Yes, 13 December 2024. Please consider that. The petitioner claims to be the first wife of one Nityaranjan Saha. The husband's name is Nityaranjan Saha, who who retired while serving as a beat officer in the
Oh, sorry.
under the respondent authority. Sister, the petitioner claims that her husband was receiving pension and he died on 29th of September 2024. Sister, the petitioner submitted a representation before various authorities, including the Chief Conservator of Forests, Personnel Management Cell, being the sixth respondent, praying for release of family pension in her favor. Stop. The learned advocate appearing for the petitioner submits that in spite of receipt of such representation, no decision on such representation has been communicated to the petitioner till date. Stop. The learned advocate appearing for the second respondent submits that the second respondent is the first wife of the said Nityaranjan Shah, and she is entitled to the family pension, and the petitioner is not entitled to family pension. First of paragraph. The paragraph. This court is not inclined to enter into such a factual dispute at this stage. Full stop. Since the representation has been made by the petitioner before the respondent authority, this court is of the view that the interest of justice would be subserved if the respondent authority is directed to consider the said representation and pass a reasoned order on such representation within a specified time frame.
Civil suit is pending on the same, if you may take a look.
Oh, you have filed a prior suit?
No.
She has filed.
Yes, on the same.
Have you
matter.
stated that in the writ petition?
I did not mention.
No, Lordship.
The suit is held before the Alipurduar district court.
Sir, all the respondents are parties, so writ petition is not maintainable. ওই যেখান থেকে রিপ্রেজেন্টেশনটা এ করেছে সেকেন্ড রেসপন্ডেন্টের সাবমিশনের পরে লিখুন the learned advocate appearing for the second respondent further submits that the petitioner herein has filed a suit being title suit number 195 of 2025 before the civil judge junior division at Alipurduar, praying for declaration that she is the legally married wife of the deceased Nityaranjan Saha, and for a further declaration that she is entitled to get share in the death benefits and family pension in respect of the service of her deceased husband. First up, since a dispute, since a civil suit is pending civil suit is pending between the private parties, wherein the private respondents have also been impleaded as defendants, this court is not inclined to entertain this writ petition. First up, accordingly, the writ petition stands dismissed as not entertained. First up, it is however made clear that this order, the petitioner is left free to proceed with the title suit number 195 of 2025 before the civil court in accordance with law.
Careful, my lord.
So you should have told me at the beginning.
Petitioner suppress.
File a civil suit.
My lord, petitioner suppress the matter. Petitioner suppress the matter to me.
Petitioner suppress.
My lord.
Thank you. Yes.
1 p.m.
1 p.m. See you at password. Yes. You are appearing.
Yes, Miss Purari Bhattacharya, you are appearing.
Well, I'm only appearing for secondary board, your lordship.
Yes. Yes, Ms. Bhattacharya, what do you say?
Lordship, this, as per our rules, your lordship, when a person is suspended, is under custody for detained for more than 48 hours, he is liable to be suspended. So, my lord, and another thing, your lordship, the school cannot allow the petitioner to rejoin without permission of board. Here, my lord, the school authority has not asked for any permission of board. And my lord, it is the DI who informed, DI have informed board on 17th June regarding this arrest of the petitioner. And my lord, thereafter, my lord, this order of suspension has been passed because it has to be passed as per the rule. As per rule 6, my lord, it says, my lord, if the teacher or non-teaching staff is under detention in lawful custody for more than 48 hours, then, my lord, he has to remain under suspension. Then, my lord, there are two things, my lord. In particular, this case, the criminal proceeding is not connected with service as it appears from the sections I find. So, my lord, only one thing can be done. Only one thing, my lord. In generally, in the cases where it is not connected with service, board that does not generally initiate disciplinary proceeding. It is generally we don't do. It is not that there is any rule, but we generally don't do. So, my lord, only one thing, my lord. Let the school authority make an application before board for
school is not here. That is the difficulty. School is not here.
Then, my lord, the petitioner himself will have to make an application.
One thing can be done, Mr. Pal. Have you submitted any representation before the board?
Lordship, no, Lordship, I was
Please
working.
submit it because the school authorities
Lordship,
have
kindly see the rules, what she's relying on, Lordship, and on the basis of that, please just whatever order is that, Lordship. Lordship, 6 suspension, Lordship. 6-3, kindly see, Lordship.
6-3.
Bottom 6-3. Next page 6-3.
Yes.
If the disciplinary proceedings is not initiated or contemplated within 90 days from the date of receipt investigation report, or if the teaching or non-teaching has been released on bail,
yes,
the concept teaching or non-teaching may be allowed to resume his duty.
So, well, who will allow? It is a board who will allow, my lord, to resume his duties subject to the condition that such joining of the teacher or non-teaching staff will not hamper the normal running of the institution. So, my lord, for that reason,
that is the essence, Lordship, that it is not connected with the school. It will not hamper anything of the school. That is
what
what
the school will say.
My
lord, that the school will say.
6-3. 6-3. English 3. 6 bottom, Lordship. Bottom, Lordship.
Oh, 6 is sorry.
That is the suspension.
6. Yes.
Well, kindly links first 6-1, your lordship.
So now he is challenging the suspension order. He is challenging the order of suspension.
My lord, what is my contention? My lord, he has been suspended as per rules. Now, my lord, the school authority cannot allow him to join without permission from the board. That is as per 6-3, your lordship. It is the prerogative of the board to decide whether his joining will hamper the service or not. So, my lord, what is necessary, your lordship? The petitioner may apply before the board for withdrawal of suspension as because there has been a suspension and it has been done.
Where is the order of suspension? There is the order of suspension.
Page
well, that is at page 35, your lordship. Page 35.
Page 35.
Yes.
It was communicated earlier, page 7 July.
It was communicated on 2nd of July.
Lordship, signed on 2nd July, earlier page, Lordship, 7 July. Earlier page, 7 July.
But that is the communication, your lordship.
7th of July.
And
the
yes.
2nd of
discipline on
I'll
13th.
do one thing. I give you liberty to submit an application for withdrawal of this.
Yes.
I direct
Yes.
them to consider that application within a right time.
And Lordship, in the light of the order
Yes,
passed by
yes,
just.
I'm recording that you are relying upon these judgments, and they will consider this upon hearing you and upon hearing the.
Lordship.
Thank you, Koeli. Thank you.
When,
Grateful, Your Lordship.
Mr. Paul, when you are taking to custody.
Lordship,
My lord, he was arrested. He was arrested 11th June 2026.
11th June. 11th June.
11th June, Lordship. 11th June.
Released on bail on 2nd July.
11th of June, taken to custody.
Lordship. Released from 2nd July.
2nd of July, released.
Thereafter, from 3rd, I attended the school, put my signature in the attendance register.
3rd July to
13th.
To 13th.
13th, second half, they have handed over the suspension order.
Then 13th, this order of suspension was
handed over to me 13th.
Order of suspension dated 2nd of July.
2nd of July.
Was handed over, Lordship. No disciplinary proceedings has been initiated.
No, not yet. It is just in the month of July. Well, a board will have to consider, Your Lordship.
Yes.
Well, a board will have to consider whether his suspension is required or not.
Yes, I'm directing you to consider the petitioner is an assistant teacher in physical education of a high school. First up, the pursuant to an FIR which was registered on 11th of June 2026. The petitioner registered on registered on pursuant to an FIR pursuant to registration of an FIR against the petitioner, he was arrested on 11th of June 2026. First up, the petitioner was enlarged on bail on 2nd of July 2026. First up, petitioner claims that on and from 3rd of July 2026, the petitioner rendered his service as an assistant teacher in the school till the second half of
first half of
13th of July 2026 and on that date and on 13th of July 2026, the petitioner was served with an order of suspension dated 2nd of July 2026. Paul, advocate appearing for the petitioner, submits that the allegations leveled against the petitioner in the FIR do not pertain to any allegation regarding the service of the petitioner in the said school. First up, the learned advocate for the petitioner places reliance upon the decisions of the coordinate bench in the case of Vasudev Mullik versus State of West Bengal and others, reported at 2004 1 CHN 32 and Gopal Chandra Patra versus State of West Bengal and others, reported at 2004 7 SLR 62 in support of his contention that
Para 6 of the judgment, Lordship.
The managing committee of in support of his contention that since the petitioner was arrested for an alleged offence committed beyond the scope of his duty as an assistant teacher, and such offence is neither directed against the institution nor the property of the institution, comma, there is no scope to keep the petitioner under suspension till the disposal of the criminal case. Full stop. Paragraph. Heard the learned advocate for the board, and heard Ms. Bhattacharjee, learned advocate for the board.
Board of Secondary.
For the board of secondary education. Full stop. She submits that the decision with regard to keeping the petitioner under suspension or to withdraw the same can be taken only after an application is only after a request in that regard is submitted by the school authority. Just a paragraph. The school authority has been implemented as party respondents in this writ petition. First up, a copy of the writ petition has it has been served. Copy of the writ petition has already been served upon the school authorities. First up, affidavit of service filed in court today is taken on record. First up, in spite of service, none appears for the school authorities. First up, paragraph. In the light of the submissions, heard the করে দিন ওই যেখানে স্কোয়েলি ভট্টাচার্য করেছিল তারপরে heard the learned advocate for the state তারপরে লিখে দিন in the light of the submissions made by the learned advocates for the respective parties, this court is of the considered view that the interest of justice would be subserved if the petitioner is given a liberty to submit an application for revocation of the order of suspension before the West Bengal Board of Secondary Education, and a direction may be passed, and this interest of justice is subserved, and the board is directed to consider the same in accordance with law. First of paragraph, WPA number such and such stands disposed of by giving liberty to the petitioner to submit an application, to submit an appropriate application before the West Bengal Board of Secondary Education, praying for revoking / withdrawing / cancelling the order of suspension dated 2nd of July 2026, and if such an application is submitted, the commissioner will consider this.
No,
who will consider?
Your Lordship. One of the president in charge. The present board will consider, Your Lordship.
The officer in commissioner or the
president in charge board.
The president in charge, West Bengal Board of Secondary Education. Sapal, please implement the president West Bengal Board as also a necessary party.
Lordship.
Being the added respondent, being the added respondent to consider such application of the petitioner and dispose of the same by passing a reasoned order by passing a reasoned order after affording an opportunity of hearing to the petitioner, the school authorities and / or their authorized representative.
Lordship, may I submit one thing?
Yes.
Well, hearing is not necessary, Your Lordship. Generally, if we receive an application from the petitioner, my lord, we will ask the school whether his joining will be detrimental to school or not. If the school say it is not, then we'll allow it. Hearing is not necessary.
But if it is against them, then you have to hear them.
Then Your Lordship.
আচ্ছা তাহলে আচ্ছা এটা করে দিন upon affording an opportunity এখানে লেখার দরকার নেই কি বললাম হ্যাঁ shall consider and dispose of the same in accordance with law as expeditiously as possible, but positively within a period of 2 weeks from the receipt of such. Because school is suffering. School will suffer because it will not be within a period of 2 weeks from the receipt of such representation, along with a server copy of this order. First up, in the case, in case the added respondent contemplates any adverse decision against the petitioner, an opportunity of hearing should be provided to the petitioner or his or her his authorized representative and dispose of the same within the time limit mentioned here.
Leave may be granted to add the party. President in charge of party of this.
Yes, একদম উপরে লিখে দেবেন president in charge করে
President in charge. West Bengal Board of Secondary Education.
is simply on the prayer of the London Court. Yes, all the ওইগুলো দেখে দিন yes service 71 you are appearing SIR SIR disposed of next disposed of next disposed of
74.
disposed of
75.
disposed of
76. 76.
disposed of
74 and 76, I will hand over the review service to the course of the.
I have one matter, serial 45.
that will be called on. Yes.
Item number 39.
My lord, I am for the petitioner. My lord, petitioner is a 59 years old widow daughter, my lord, who claimed family pension as a widow daughter-in-law. My lord, kindly comes to page number 42.
Page number 42.
42, my lord. My lord, the department is asking me for some documents which is, my lord, beyond my control. My lord, the original service book, my lord, the appointment letter. My lord, my father was, my lord, retired in the year of 1983. My lord, at that time the petitioner was a minor.
Yes, Mr. Ghosh. When the employee was granted family pension, employee was granted pension, wife was granted family pension, how do you need this? Original service book, letter of appointment, service confirmation certificate, option and fixation, all were within you. Why do you need this?
I have tried to get instruction from the last of them.
That is a different thing. These documents may not be needed. If the first time it's there, the employee was granted the pension, wife granted family pension, why do you need these documents? Then
We try to get the instruction, we have the instruction.
what instructions? I direct you to consider that within that these documents you cannot claim now. The the order dated 4th of November 2025 passed by the Sub-Inspector of Schools, Shodor 3, Roman 3, III, Circle, Kuch Bihar, is under challenge in this writ petition. First up, the petitioner is you are the daughter?
Yes, madam, the widow
Is
daughter.
the widowed daughter of one Anil Kumar Vishwas Singh's disease. First up, the said Anil Kumar Vishwas was served as a teacher in the primary section of Guriyahati AP School in the district of Kuch Bihar. First up, after his retirement, the petitioner, the said Anil Kumar Vishwas was enjoying the pensionary benefit. First up, did you furnish any document, your father's PPO or your mother's?
No, madam, I didn't.
Then if you cannot submit any document, it cannot be processed.
My father was died in the year of 1993.
No. You have to submit some document. Otherwise, how they will relate?
They are related. They have been related. They are only submission.
Submit some documents. Otherwise, it's difficult.
Let there be direction upon the district inspector. Whatever the documents the petitioner will submit. But
what documents you have?
I have to take instruction regarding that.
Let them file a supplementary evidence.
You file supplementary affidavits disclosing certain documents. And কি বললাম? Paragraph. By the order, impugned, the petitioner, by the order impugned, the petitioner was asked to produce certain documents. So the learned advocate appearing for the petitioner submits that the petitioner submits that the said documents is not under the custody of the petitioner. Full stop. The learned advocate appearing for the state submits that unless certain documents are produced, it is not possible for the respondent authorities to process the claim of the petitioner. Full stop. No document has been produced by the petitioner in this writ petition to show that that her father was enjoying the pension. Full stop. No documents has also been produced to show that her mother was enjoying the family pension. Full stop. Faced with such situation, the learned advocate appearing for the petitioner prays for liberty to file a supplementary affidavit. Full stop. On the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit. Full stop. Let such supplementary affidavit be filed within 2 weeks from date. Full stop. Petitioner will be at liberty to mention this matter for inclusion after the affidavit, supplementary affidavit is filed and served upon the learned advocate for the state. Yes, next.
My lord, in this matter, on my prayer lordship at 50 today. Kindly takes it up day after tomorrow.
What is this matter?
Excise matter for reconstitution of license, they were supposed to supply the original order so that we can prefer the appeal. Which was passed on 2nd of July. My fault, my lord, I could not communicate.
So I direct you to communicate it, to serve it to Mr. Ghosh with that order has been passed.
Yes, order has been passed.
So served by Thursday.
So let it be kept on Thursday. We will receive it here.
Why?
Otherwise, my lord,
That will not be done.
again, my lord, they will not comply. Notice, communications. Let it be there, my lord.
The learned, Mr. Bhattacharya, learned additional government PDF prays for time to produce the copy of the order passed by the authority, passed by the adjudicating authority.
Adjudicating authority.
Passed by the adjudicating authority to establish this matter when? Thursday.
It's a political case.
29th. List this matter on 29th under the heading for orders. For orders I am keeping.
Order number 41.
Yes.
My lord, in this matter, I am appearing. The unconditional apology, my lord, to appear virtually.
Yes, yes.
My lord, am I audible?
Tender matter, which your lordship had partially
Yes, yes.
considered. The tender matter, my lord, where we supplied the documents.
Yes, yes.
My lord,
For them to
before I
respond.
start, my lord, I want to place a judgment of Honorable Supreme Court where the scope of interference under 226 is explained, my lord. This is judgment of Jagdish Mandal versus State of Odisha, where the court my lord, page number 6. Page number 6, 18.1 paragraph. My lord, the court has
Page
says
number?
when there is 6, my lord, the internal page number 6, paragraph 18.1.
18.1, yes.
My lord, this is a judgment of where the Supreme Court has referred to another Supreme Court judgment where they have categorically said that when there is an infirmity in the decision-making process, the court can interfere.
Yes.
My lord, also in subsequent paragraph, the court has explained whether the scopes, my lord, here where a tender matter can be entertained, my lord. This is my presentation as last day. My respective other side senior had mentioned the judgment. I placed the judgment.
What? Which paragraph? 18.1. Then which paragraph?
My lord, 18.4 again. Subsequently, 18.4, there is another judgment in page number 9. In the third paragraph in the judgment, if I may please.
Yes.
But the state, its corporation, instrumentalities, and agencies are bound to adhere to the norms, standards, and procedures laid down by them and cannot depart from them arbitrarily. Though the decision is not amenable to judicial review, the court can examine the decision-making process and intervene it if it is found vitiated by malafide, unreasonable, and arbitrary. In this petition, I have not challenged the decision, I have challenged the procedure they have used. Last year, my learned senior friend had submitted some documents which actually supports my contention.
What do you say to the observations, 1 or 2 lines thereafter? It starts with even when some defect is found in the decision-making process. What do you say to this?
Even the observation, the
Yes.
paragraph number 19, in page number 10, the court has said that what are the conditions.
No.
Paragraph.
What do you say to this 18.4 third paragraph which you are saying? What do you say to this observation? Even when some defect is found in the decision-making process.
The defect has to be in fair and square. It cannot.
Please place that. Please place that observation.
The court should always keep the larger public interest in mind in order to decide whether its intervention is called or not. Only when it comes to a conclusion that overwhelming public interest requires interference, the court should intervene.
No. You have skipped that observation. That sentence is very
even when
interesting.
Yes, my lord. Even when some defect is found in the decision-making process, the court must exercise its discretionary power under 226 with great caution and should exercise its only furtherance of public interest and not merely to make out a legal point. My lord, that is what I'm placing, that the public interest is good. No, my lord, this is actually
against you, sir.
This is from me, my lord. Why
Even by making a legal point and showing that there is an error in the decision-making process.
No, my lord, there is not an error. It's an arbitrariness. There is an arbitrariness in the order. My lord, I'll place the case.
Yes.
My lord, this is, my lord, when by the documents they have submitted, my lord, the learned senior friend of the joint enterprise, the private respondent, my lord, in the paper book, the submission they have made, my lord, in page numbers, 1, 2, 4. My lord, in the court, they have made a clarification. They asked, page number 3, they have asked for a clarification. My lord, in this clarification, they have manually submitted the documents. The documents which were missing in the portal, they have manually submitted. In the clarification stage, they denied, my lord, in page number 5, the first authority said that no offline documents can be submitted and you are rejected on the basis that your documents were unauthenticated. Subsequently, they filed an appeal. Admittedly, they filed an appeal. The appeal authority did not overturn the judgment. They have just sent it back. My prayer is this: if every unauthenticated document becomes authenticated through appeal, the entire premise of e-tender being transparent and crystal clear to every party will go away. Any day, anyone can come up with a paper that is missing and they can file an appeal and they can submit it, saying that, see, I have missed it and this is my document. This is what my public interest is going away. Because e-tender was supposed to be fair and square and everything has to be transparent. In the portal, there was authenticated documents which was compulsory. They did not supply it. Subsequently, through an appeal, they supplied it manually. And that got authenticated and saying that, fine, you have submitted it manually, which is not allowed as per NIT. Subsequently, for every tender, people will start missing papers and they will file an appeal and they'll submit those papers. This is where the public interest is getting affected. And it is not only rectifiable, it's arbitrary they have done it. I'm not on the point of whether they have done it within time or not. My point is that how can, through an appeal, of nature of a document change from authenticated to unauthenticated? We as other tenderers, where we applied, we had to submit every document as per the NIT. This person person name miss a paper, they cannot submit those paper which is not there in the portal. Even today also the portal shows unauthenticated BOQ. The nature of the documents is changing. This is arbitrary. This is, my lord, otherwise
All
the
right.
entire the transparency of e-tender will go away. So that is all my prayer is.
Yes, followed.
The transparency
Yes.
may be maintained. But if this person is allowed to submit documents which is not there in portal, then subsequently for every tender, people will miss our documents and subsequently file an appeal and submit those documents.
Yes.
The entire process of e-tender will become odious, my lord. That is my humble submission is.
Yes.
They are not verifying it. They are exactly changing the nature of the documents and they are allowing a documents which is not there in the online portal. This they cannot do.
Anything?
No, my lord,
Anything
that is
more?
no, my lord, that is my humble submission is that this becomes a very arbitrary decision they have taken. A paper which is not there in
Yes.
the portal came into offline mode, which is not allowable under NIT rules, notice inviting tender rules, and that has been allowed, and they have been dropped from being disqualified to qualified on those documents, and which is still not there in the portal, my lord. This I can place out that it is still not there. The authenticated documents is still not there, my lord.
Yes.
Milord, page 64 once, Milord. Look, my reason of disqualification. Milord, top of the page, Milord. My name appears at serial number 3. BOQ related to credential not authenticated by the issuing authority, hence disqualified. So the ground was not that I did not submit a particular document. I submitted a credential in accordance with the NIT, but it was not authenticated. In my clarification, Milord, the bunch which I had handed up, Milord, page 4. My clarification letter dated 13th March 2026. It was a 10
Where is
page,
that?
10 page bunch, Milord. It was handed up. It was with your lordships. In your
It
lordships
was
file.
thereafter given to you to make Xerox copy.
So, Milord, kindly take
Both the
Milord.
copies were given
Yes,
back
I'll
because on those dates. Yes.
My
On
copy-
those dates to make photocopies and then return.
I think yes, state had relied on two pages, my lord.
Yes,
I think
yes.
possibly that is there before your lord.
That is here. এগুলো কোথায় নেই তো? It's not here.
Not there.
So what is it? Do you have those copies? Because I have returned to both of you to make copies to serve it to them.
না, এটা ঠিক কিন্তু ফেরত দিয়েছি।
No, ফেরত দিয়েছে আমার I have my lord.
You don't have.
Here, I can give it to.
No, what are the documents you have handed up? Please check up whether it is within this or not.
This is one
Either
letter
দেখান
is
তো।
of 1st of April
না,
2026.
এর মধ্যে নেই। Milord, my bunch was separate. These are my communications and the communications I received.
This was
He
my-
had the
You don't have a copy of
interdepartmental
that?
communications.
Madam, you have the copy of the documents. So what is it you have not given to him?
Yes.
My lord, I've
Where is
received
that?
it.
All
আরে
I
PDF
don't have. You have the soft copy.
Yes.
Please mail it. Yes, Mr. Bhattacharya. Yes, Mr. Ghosh.
Milord, page 4, Milord, of my bunch. The second page of the clarification. Page 4. The second page of my clarification letter. Dated 13th March
Where
2026.
do I get the page numbers?
But it is paginated, Milord.
Oh, yes, page 4. Yes.
Yes, Milord takes the first line. Now, in continuation of the BOQ, we are also submitting the final deviation cum financial implication statement for the work duly signed and authenticated for your kind perusal. So since they have stated that the document which I originally uploaded was not authenticated, we submitted the entire financial statement and the authenticated copy of the document.
No, tendering authority is the same authority.
Same authority.
No, ma'am.
Now, my first, according to the clause in the NIT, in
No,
case of
this is of the chief engineer, not this.
Yes.
And this BOQ was of which authority?
This BOQ was from a different department. This
Yes,
was
from a
Milord,
different
from the same department, in fact, the irrigation and water,
department?
irrigation and waterways.
Oh, irrigation and waterways.
Yes. That Milord would find at page 9, which is their communication, state's communication. Page 9 of, the
of your document.
of my batch. The last paragraph.
Yes.
When Milord, the tender authority, the appellate authority, that is the secretary, sends the document for verification. Examining all the relevant documents received and in consultation with the chief engineer South, the superintending engineer attached to chief engineer Northeast Irrigation and Waterways Directorate tender inviting authority for the instant ENIT is directed to verify the authenticity of the relevant documents in support of technical credentials from the Jalpaiguri, from the executive engineer, Jalpaiguri Highway Division, PWD Roads. So my credential was obtained from Jalpaiguri Highway Division, PWD Roads Directorate, which the superintendent engineer was asked to seek a clarification whether this is a genuine document or not.
Yes. What
Once
is the clarification?
the clarification was produced by Mr. Bhattacharya, which shows that upon being found to be genuine and authenticated, my technical bid was subsequently accepted and my disqualification was set aside by the appellate authority. Now, so therefore, Milord, what I wish to demonstrate is, Milord, that it is not a case where a subsequent document has been planted in support of my candidature. That is impermissible in according to the NIT. Had that been the case, that would have
দেখিয়ে দিন একবার এটাকে বাবা এটা তো
Actually, the photograph which was taken possibly was not taken clearly. File নেই, আমরা return করে দিয়েছিলাম, দেখুন তো এই দুটো চিঠি আছে. No, I was just saying that whether those two letters are there in the file of your lordship.
Please check up.
দেখুন তো, because those are legible. Here, my lord, possibly
No,
while
it's
taking,
not very.
no, which is now before your lordship, it is not. Because while taking the photograph,
1st of April and 6th of. Oh, no,
Yes.
sorry. This is the year.
there are too many papers there, my lord.
It is here. Yes.
Now, Milord, admittedly, in conducting the entire process, Milord, the stipulated timeline of 48 hours have been breached. I cannot improve that. But at the same time, Milord, on the earlier occasion, I had also submitted, Milord. Now, Milord, after Michigan rubber, the position is each and every deviation, whether it goes to the root of the contract, has to be looked into. So, Milord, here,
Where is that? Where is that?
Milord, I am not carrying that judgment, Milord.
He's citing decisions.
Milord, I can come back tomorrow, Milord, with the judgment if Milord desires. But Milord,
You have the reference with you.
I can, Milord. I'll just write it down and submit,
Yes.
Milord.
Yes.
So, Milord, that 48 hours have been breached.
Because he has to give a reply to that.
Yes,
Please
because
give the citation so that he can.
48 hours have been breached, no doubt. But this 48 hours,
48 hours is as per which clause?
Millard would find Millard at page
And at
42 of the writ petition.
15.4.
15.4 at page 42.
No, that has not been breached by you. That is by the authority.
In the hands of the authority. My obligation was to file the appeal, which was done on the next day itself. On my part, there was no delay.
Yes. Yes.
And Millard, so far as on the point of public interest, Millard, it is always in the interest of the public, Millard, to have more and more tenderers on board before the financial bid opens. So excluding me is not subserving public interest. Rather than that, including me serves public interest in the
That will also
instant case.
serve your interest, private interest also it will serve.
Definitely,
Including
and my professional
including you
interest
will
also.
serve your private interest, Mr. Ghosh.
And my professional interest also, my lord.
Yes.
So that's all I have to submit.
My lord, may I please reply to this? My lord, the very next page, the page number 6.
May I, my lord, just make one submission regarding the documents. Verification. If your lordship kindly comes to page 32 of the writ petition.
ওইটার কোনো judgment পেলে specific ওটা খুঁজে দেন। 32, yes.
My lord, there is a table. Below the table, it's written note.
Yes.
That kindly sees that it is desirable but not mandatory that all the documents stated above in PDF file shall be uploaded by bidders only in specified designated folders. No offline document will be accepted and considered during tender evaluation stage from bidders before publishing result of final selection of L1 by publication of FB sheet. Verification of authentication of bid documents during bid evaluation by TEC memorandums.
So according to you, this was a verification done from the credential issuing authority.
Yes, and my lord, the last line may be undertaken from bidders.
Yes.
Or
May be
directly
undertaken
yes.
from bidders or directly from PQ,
Yes, my lord.
credential issuing authority.
authority.
What is PQ?
Pre-qualification eligibility. Pre-qualification eligibility.
তাই হবে। Not very clear on PQ.
Going to the root of the
What is PQ?
What is we are trying to find out.
My lord, that is pre-qualification credentials, PQ credentials. They have
Yes,
Pre-qualification credential.
Yes.
So my lord,
So according to you,
yes,
this is not a breach of the tender conditions. It's not that he has given any permission to submit further documents. Only a verification was done by you from the issuing authority.
issuing authority. my lord.
With regard to the credentials.
Credential, only that.
Because since he has given clarification, on the basis of that, you got it verified from the PQ issuing
Yes,
authority.
Yes, that is great.
My lord, may I place on this?
Yes.
In the page number 5, my lord, as Mr. Ghosh has mentioned, they had subsequently submitted the documents which is authenticated, which is compulsory as per the NIT. In page number 4, page number 4 of the reply. In the attachment, they have given the authenticated documents manually. In the very next page, the first authority says that you cannot submit that manually on offline mode. And at the page number 5.
Yes.
The respondent says, the authority says that in response, may I please inform that you have been disqualified due to non-submission of DOQ duly authenticated by the issuing authority. Further, in clause note point 4.2b, no offline documents will be accepted and considered during tender evaluation from bidder before publishing result of final selection of L1, etc. My problem is like the reason for their disqualification is not unverified. They are saying that it's unauthenticated. My lord, even coming back to the reason, my lord, in the process submission page number 2, the reason is not unverified, it's unauthenticated. That is a mandatory. They are missing a mandatory documents which they subsequently submit manually. But even in the first, even in the appeal stage, they did not overturn or say that no, fine, it has been found to be authenticated. The appellate authority has sent it back saying that get it verified, not authenticated. My lord, my point is that the documents has to be authenticated. They are changing the nature of document. If the documents is authenticated and authenticated DOQ has to be there, then it should be there in the portal. It's a very basis of this experience certificate is the authenticated DOQ. They are not verifying it. They are making something which is unauthenticated, authenticated. This is, my lord, the change of nature of document. This cannot happen in the guise of a verification, my lord. My lord, even the appellate authority in page number 6, not page number 6, my lord, sorry. My lord, page number 7. My lord, page number 9 of the Mr. Ghosh's submission. APP
Yes.
08. My lord, in the second paragraph, he has said that your bid is declared not qualified by TIA on the ground of BOQ related to credential not authenticated. Subsequently, what he does, he sends it back to get it verified, not authenticated. My lord, even the third paragraph, examine this NIT is directed to verify the authenticity. My lord, if I have
Which
not
page you are
submitted-
placing?
My lord, page number 9. My lord, of Mr. Ghosh's
9.
submission. My lord.
Yes.
This is
yes.
the order of the appeal, the APP 08.
Yes.
Well, in second paragraph, the appeal authority says that your bid is declared not qualified on the ground of BOQ credential not authenticated by issuing authority. On scrutiny, it is found the appellant authority have submitted an online generated BOQ. This is where the document is problem. The NIT rule says that every tender document has to be authenticated. Subsequently, while passing the orders, he is sending back for verification of the authenticity. This is change of nature of documents, my lord, as per my humble understanding. This cannot happen through verification. They can verify whether the documents were original or not. Whether a documents.
No, this only 1 minute. Paragraph 2 of page 9 of Mr. Ghosh's document. This item number 1 is online generated BOQ.
Yes,
2 is completion certificate and 3 is statement. So 2 and 3 also relates to 1.
Yes, madam. 2 and 3 relates to 1. The 1 is the main document they had to submit by their authenticity.
No, I'll just clarify.
So they have submitted 1, 2, and 3.
Millard,
yes, the 1 was unauthenticated.
Credential, Millard, is a 1-page document. Once the completion certificate is prepared, along with that, the department issues a credential so that I can use it in future contracts to show that yes, this person has done this work. In support of the credential, Millard, there are financial statements which shows that the work was actually done. The bill I have submitted, the processment of the bill, etc. So credential is supported by other documents, but for the purpose of brevity in contract tender process, only credentials are accepted. In my case,
completion certificate and other things were
not required.
Yes.
Since my credential was
but
not,
you had submitted when? This
yes, with the tender.
That was in addition.
Yeah, no, that was not in addition. 64, Millard, kindly once come. That's why I started with page 64 my submissions.
Yes. Yes.
BOQ related to credential not authenticated by the issuing authority. So it is not a case of non-submission. It is a case of submitted but not authenticated.
Yes, BOQ.
Yes.
So that was an online generated
generated document.
But item number 2, completion certificate and statement, you had also submitted.
Yes. That was submitted. That was not a ground that I did not submit those also. That's why I am disqualified. It was only that the particular document was submitted but not authenticated. So the question was whether the credential submitted was genuine or not.
Decision. We have got the decision.
Yeah, Millard, I have written down the citation, cost title, and the para numbers.
Yes.
Millard, this is 2012 8 SCC.
Bar kora jabe?
Millard, para 20 and Millard 32.
Mr. Ghosh, please place those because he has to give reply to that. Otherwise.
2012 8 SCC.
2012. 2012 8 SCC 216. Michigan Rubber India Limited versus State of Karnataka.
8 SCC page
216.
Yes. Do you have a soft copy?
Yes, Millard. SCC
Please
copy.
give me a soft copy. Paragraphs?
Millard, I have written down. Ektu paragraph number bolo na, jitu toliye.
20 and 31.
20 and 31.
20 and 31.
31.
Please give me the soft copy.
Net of complete.
A soft copy may be sent to my junior.
Can you send a soft copy to your?
Yes, Millard, we will send.
Please send it.
Indian.
Yes. প্রথম টোয়েন্টি and 31.
31 বললাম 31 মিনিট the last paragraph, last but one paragraph probably. हम तो वही देख के बोला नहीं होता है ना.
Indian. मैं बहुत बार तो सेम ही इसीलिए ओके मेरा
So this is for what proposition, Mr. Ghosh, you are citing?
Millet, that in a tender process, court will only look whether the decision making process was arbitrary.
This is an institution
That is what my
or,
judgment also.
or discriminatory to favor someone.
Yes,
Arbitrary or discriminatory, tailor-made to favor someone.
yes. So where is that paragraph?
Millard, SCC's paragraph, Millard, may not match. I was citing the paragraph from the India Canon copy. Here, Millard, it is para 31, as observed earlier. It starts with Millard, as observed earlier.
What the decision made? Oh, yes, yes, it's malafide or intended.
Yes.
That is paragraph 24.
24, probably yes, Millard.
24.
And then, Millard, the last but one paragraph.
Therefore, a court before interfering should suit the questions. Is adopted or a decision made by the authorities malafide or intended, or whether the process adopted or decision made so arbitrary. And answers are in the negative, then there should be no interference. So if these answers are in the negative of those questions, then it cannot be
It cannot be
interference.
It cannot be interference. And Millard would also find, Millard, para 19, the principles have been quoted. Millard, A, B, C.
Here you have been downloaded from where?
Millard,
This copy?
Millard, this is from SCC, Millard.
This is from SCC, the one which you have given.
No, it
Does
Millard,
not
this-
appear to be so.
Millard, this is your
India
lordship.
Canon.
India Canon.
India Canon, there might be.
AIR.
I like Bana Baba Dara. SCC India Canon, our AIR news.
Because,
Millard, India Canon,
there
para
might be
19.
some mistakes.
But sometimes,
is-
Millard, paragraphs number don't
Not
match.
only paragraphs, some words.
Yes, yes, yes.
missing.
It happens, Millard. It
My lord
happens.
can read AIR also.
All right, let me see if
Millard, para 19 from the India Canon's copy, Millard, para
paragraph
19.
19.
Yes, Millard.
Yes, what do you say?
Yes, my lord. My lord, the documents again, my lord.
Merits only on this judgment. Don't argue on merits.
No, my lord, I'm not
Only
arguing
on this
merits.
judgment.
Yes, my lord. My lord,
Yes.
page number 64, my lord, if you can come to once again, my lord, page 64 of the petition. What they
Yes.
have said, they have said that the BOQ related to credential not authenticated. My lord, this is the reason they have been disqualified. My lord, your lordship can kindly come to page 33 of the petition.
Yes.
My lord, 33, the petition 4.2C Roman 3. 4.2, my lord, it starts with 4.2C2. Then there is a 4.2C3, page 33 of the petition.
Therefore, yes.
Well, that is there is a paragraph 4.2C within bracket Roman 3. The eligibility
This you have
criteria.
placed. This.
Yes, ma'am.
This you have
Well,
placed.
this
Don't re-argue. Only,
my lord,
only
my-
on this decision, please give your reply.
My lord,
Only on this
my-
decision, please give a reply.
Yes, my lord. My only
Yes.
humble submission is this, my lord. If a nature of a document keeps on changing through appeal, the entire procedure of e-tender being fair and transparent goes away. My lord, why I will tell you, my lord, because nowhere in their submission or during the course of appeal or clarification, they have said that they have changed the nature of document. They have submitted which is not there in the portal initially. Well, they have
Yes.
verified it. I'm not challenging on the grounds of verification. I'm challenging whether through verification they can change something which is unauthenticated to authenticated. That is all my submission is, my lord. I'm very limited on this point. Can a nature of a document be changed to verification? If yes, my lord, then subsequently a lot of documents which we might miss, we can file an appeal and change it. Because it was a compulsory criteria to submit an authenticated BOQ. My lord, my only humble question is this. Whether the fairness of the NIT or the transparency will be maintained if something which is not there in portal is checked through back end and they have been qualified from change from the status will be changed from disqualified to qualified. That's all my humble question is, my lord, to this court.
Yes.
Because the ENIT process, the entire process is based on transparency and online.
My lord, may I be kindly excused, my lord?
The petitioner has prayed for setting aside the decision of the secretary, Government of West Bengal Irrigation and Waterways Department and the appellate authority dated 30th of March 2026 and the memo dated 27th of April 2026 issued by the superintending engineer attached to Chief Engineer Northeast Club Road, Jalpaiguri, in this writ petition. First of all. Petitioner, paragraph A, proprietorship concern carrying on business of civil, carrying on business under the name and style of Messrs. Shubham Construction.
If I may, my lord, it's a partnership firm. My lord, In the cost title,
You
it
have
is given
said
as partnership.
partnership firm.
And cost title, it is partnership, it is mentioned, but in somehow it has come in mistake. There's a
কি বললাম, petitioner, a partnership firm carrying on business under the name and style of Mr. Shubham Construction is engaged in the execution of civil and infrastructure projects under various government departments and its instrumentalities. First of all, petitioner claims to have participated in a tender process floated by the Government of West Bengal, Irrigation and Waterways Directorate, floated by the Office of the Chief Engineer, Northeast, তারপরে Government of West Bengal, Irrigation and Waterways Directorate, Wide ENIT, dated, what is the date? Wide ENIT. What is the date of this tender? Dated 11/2/11/3. না,
ওই প্যারাগ্রাফটা জাজমেন্টের কোন প্যারাগ্রাফ যেটা কোট করা
dated 30th of January 2026. Being ENIT number page 28. WBIW सब capital से /AC caps /C caps within first bracket any bracket closed /NIT -04 within bracket small e /2025-26.
essential requirement paragraph
First of
28.
The petitioner alleges that though the private respondent who also participated in the said e-tender process was disqualified by the respondent authority, but was subsequently but subsequently declared as qualified in the technical bid. Full stop. Next, the learned advocate appearing for the petitioner submits that the notice inviting the small dash tender specifically states that the intending contractors are required to download the e-tender documents directly from the websites and submit tender through online mode. Full stop. He further submits that the NIT specifically, notice inviting tender in the bracket for short NIT. that though he further submits that though the NIT specifically states that no offline document will be accepted and considered during tender evaluation stage from bidders, the respondent authorities have allowed the private respondent to submit documents in physical form at the tender evaluation stage. First up, he submits that the documents which were submitted by the petitioner, private respondent, subsequent to the submission of documents through online mode were taken into consideration by the authorities and was thereafter declared and was subsequently declared as qualified. He further submits that the authorities have also violated the process of technical evaluation during the tender as laid down under clause 15.4 of the NIT by not adhering to the timelines stipulated therein for technical evaluation of the tender. The learned advocate appearing for the petitioner places reliance upon a decision of the, yes, where is it reported?
Madam, this is copy of a Supreme Court. The reportable order is AIR online. I don't.
AIR?
Online. Madam, AIR online. 2006 SC 645.
2006 SC
645.
645.
Yes, madam.
The learned advocate further, the learned advocate for the petitioner submits that the state and its instrumentalities are bound to adhere to the norms, standards, and procedures laid down by such authorities while floating a tender and cannot depart from them arbitrarily. First up, he submits that if the state and its instrumentalities, while evaluating a tender, departs from the standard norms and procedures arbitrarily, the court can examine the decision-making process and interfere if such decision-making process is vitiated by unreasonableness and arbitrariness. Full stop. He, in support of such contention, he places reliance upon the decision of the Honorable Supreme Court in the case of Jagdish Mandal versus State of Odisha, reported at AIR Online 2006 within bracket SC
As has been done in Jagadish
645.
Jagadish Mandal, 9, State of Odisha.
He thus submits that the appellate authority, the appellate authority acted in an arbitrary manner by allowing the documents to be submitted by the private respondent at the tender evaluation stage and getting the same authenticated during the pendency of the evaluation of the tender. Yes, these are your submissions?
Yes, ma'am. May I?
Yes.
Millard, before Millard records my submission, Millard, one of my competent junior, Millard, he has already researched and kept a more appropriate judgment in the file which I missed. And Millard, Jagadish Mandal and Michigan Rubber both have been discussed. Millard, para 46 onwards. And
what is the cost title of this judgment?
Millard, this is Central Coalfields versus SLL SML joint ventures. This is 2016 8 SCC 622.
Reshmi Metallics has been.
Yes, Reshmi Metallics. Thereafter, Millard would find Poddar Steel and Millard, obviously the one which he was relying on, Millard. 46 onwards, 48 and 49. 48, Millard, is what I am, Millard, trying to submit. Jagadish Mandal has also been discussed, 47. 2016 8 SCC 622. 2016 8 SCC 622.
So you are relying on paragraph 48.
46, 47, 48. The decision of the authority has to be respected. Unless, Millard, on the face of it, it is malified or designed to, Millard, tailor-made to favor someone. This is, Millard, the test.
Yes, Kela.
This actually goes in favor to a certain extent in my case also, because in para 52 it says that if a mode modus operandi or a certain way has been prescribed, it cannot be.
All
referred to.
decisions, in all decisions, the one which you have cited, something is against you. So it's better not to cite decisions in these matters. So some will be in favor, any decision which will be referring to, you'll be finding some paragraphs in your favor, most of those are against you. And also it applies equally to Mr. Ghosh. So that is why you have to choose while citing a decision, which one to be referred to. That's important. While referring to decision, that's very important. Mr. Ghosh, learned advocate appearing for the private respondent, submits that the petitioner submitted the submitted an online generated BOQ, completion certificate as well as the statement showing the actual quantity executed in support of the credential during submission of online bid. Full stop. He submits that immediately after the technical bid was immediately after the petitioner came to know from the decision of the superintending engineer dated 11th of March 2026 that the private respondent has been disqualified as the BOQ relating to credential was not authenticated by the issuing authority, the private respondent immediately thereafter approached the superintending engineer by a letter dated 13th of March 2026, thereby clarifying the points on which the bid of the private respondent was cancelled. So he submits that the superintending engineer did not consider the clarification made by the private respondent by referring to note I touch means small I, of 4.2 capital B of the NIT, which states that no offline document, full stop. He submits that immediately thereafter, the petitioner preferred an appeal before the appellate authority, preferred an appeal before the Mr. Ghosh, where is your appeal petition?
Milord, it is in the bunch, Milord.
Is in the bunch?
Yes, Milord. I'll just
preferred an
Number
appeal
6.
before the appellate authority by later dated 17th of March 2026, and the appellate authority after hearing the petitioner and examining the relevant documents requested the tender inviting authority, requested the concerned superintending engineer to verify the authenticity of the relevant documents in support of the technical credential submitted by the private respondent. He submits that as per the direction of the appellate authority, the relevant documents has been verified by the executive engineer, Jalpaiguri Highway Division, Jalpaiguri, and the same was found to be genuine. And accordingly, the private respondent was declared as qualified. Full stop. Mr. Ghosh submits that it is for the authorities to take a decision whether a it is for the authorities to decide whether a term of NIT is essential or not, and such decision by the authority issuing the NIT should be respected. Full stop. In support of such contention, he placed reliance upon a decision of the Honorable Supreme Court in the case of Central Coalfields Limited and another versus SLL/SML, joint venture consortium and others, reported at 2016, 8 SCC 622. He also placed reliance upon a decision of the Honorable Supreme Court in the case of Messrs. Michigan Rubber Industries Limited versus State of Karnataka, reported at 2012, 8 SCC 216. In support of his contention, with regard to the scope of the power of judicial review in contractual matters. Just a paragraph. Mr. Bhattacharjee, learned additional paragraph. Mr. Bhattacharjee, learned additional government period, submits that the documents submitted by the private respondent were verified from the credential issuing, from the pre-qualification credential issuing authority, and after such verification, it was found that the document submitted by the petition by the private respondent was genuine, and accordingly, the private respondent was declared as qualified. First of paragraph, heard the learned advocates for the parties and perused the materials placed. First step, the primary grievance of the petitioner is that the private respondent was allowed to submit documents through offline mode at the tender evaluation stage in violation of the terms and conditions laid down in the NIT. First up. It is not in dispute No, it is not in this Nalike. It appears from the documents placed on record that the আচ্ছা তার আগে এখানে একটা লাইন লিখে দিন in course of hearing of this writ petition on 23rd of July 2026, Mr. Ghosh Lahaned advocate appearing for the private respondent filed a bunch of documents including the letter dated 13th of March 2026 addressed to the superintending engineer clarifying, making certain clarification with regard to the disqualification of the private respondent in technical bid evaluation sheet, semicolon, the response of the superintending engineer vide memo number 236 dated 16/3/2026, semicolon, the appeal petition dated 17th of appeal petition filed by the private respondent dated 17/3/2026, semicolon, the memo dated 30 March 30/03/2026 issued by the appellate authority semicolon and full stop. কি বললো মিস্টার ঘোষ কি বলে শুরু করলো? Which were taken on record. Full stop. A copy of the bunch of documents was directed to be supplied to the private respondent.
Petitioner.
Full stop.
To the petitioner.
To the learned advocate for the petitioner. Full stop. Paragraph. Mr. Bhattacharjee learned additional government pleader also filed the copy of the memo number 295/W471-J dated 1/4/2026 issued by the assistant superintending engineer and the memo number 418 dated 6/4/2026 issued by the executive engineer Jalpaiguri Highway Division, Jalpaiguri, which were taken on record. Full stop. Copy of such documents were also supplied by Mr. Bhattacharjee to the learned advocate for the petitioner. Full stop. The hearing of the writ petition was adjourned on 23rd of July 2026 to enable the learned advocate for the petitioner to consider such documents and to make submissions on the next date. Full stop. Paragraph. From the documents placed before this court, it appears that the petitioner submitted the submitted an online generated BOQ to capitals, semicolon, completion certificate and a statement showing the actual quantity executed in support of the credential during submission of online bid. Full stop. The completion certificate and the statement showing the actual quantity executed in support of the credential were found to be duly authenticated by the issuing authority. Full stop. The only dispute is with regard to non-authentication of the BOQ submitted by the petitioner, by the private respondent,
Page 64.
relating to the credential. Full stop. The question that arises for consideration is whether the record reveals that the appellate authority, after considering the documents submitted by the petitioner, by the private respondent, issued a memo dated 30/3/2026 directing the superintending engineer attached to the chief engineer, Northeast, Irrigation and Waterways Directorate to verify the authenticity of the relevant documents in support of the technical credential submitted by the private respondent from the executive engineer, Jalpaiguri Highway Division, PW within brackets Roads Directorate, Jalpaiguri, before taking a final decision. Full stop. The question that arises for consideration is whether such verification of the technical credential as submitted by the private respondent was done in violation of the terms and conditions of the NIT. Full stop. Note, NOTI, appearing after point 4.2, capital B, specifically states, at this stage it would be beneficial to take note of note I appearing after point number 4.2 B, which is extracted herein after it. এই ব্র্যাকেটের মধ্যে শুধু আইটা, পেজ 32। After going through note I, this court is of the considered view that though no offline document can be accepted and considered during tender evaluation stage from bidders before publishing result of final selection of L1, L capital 1 by publication of FBE sheet, but verification of authenticity of bid documents during bid evaluation by tender evaluating committee may be undertaken from bidders or directly from pre-qualification credential issuing authority. First up, paragraph. In the case on hand, the private respondent has submitted the POQ through online mode along with various other documents in support thereof. First up, the BOQ in order to verify the authenticity of the bid documents during bid evaluation, in order to verify the authenticity of bid documents, the appellate authority directed the concerned superintending engineer to verify the BOQ, that is the credentials submitted by the private respondent from the credential issuing authority. First up, thus, note I of point 4.2b specifically empowers verification of authenticity of bid documents directly from the credential issuing authority. First up, paragraph. In the case on hand, the document submitted by the private respondent through online mode was only verified from the credential issuing authority. First up, thus, it is not a case of submission of documents in physical form at the tender evaluation stage. First up, verification of authenticity of bid documents from the credential issuing authority is permissible as per the terms and conditions stipulated in the NIT. First up, this court is to the mind of this court, the appellate authority did not deviate from the terms and conditions or the procedures, from the terms and conditions, from the procedures laid down in the NIT for the purpose of evaluation, during the tender evaluation stage. First up, Point 15.4 of the NIT stipulates certain timelines for the purpose of performing certain acts. First stop, immediately after the order rejecting the technical bid of the private respondent was published, the private respondent issued a letter, submitted a letter clarifying clarifying such aspect, and since such prayer was rejected by the concerned superintending engineer, the private respondent immediately approached the appellate authority. First up, the petitioner cannot be faulted for any delay on the part of the authorities in disposing of the appeal preferred by the appeal file by the
private respondent cannot be faulted.
Petitioner absent. সবগুলোই না petitioner বলে যাচ্ছে, private সব করে private respondent.
In that respect, may I just interrupt your lordship once? Regarding the time taken by us on the earlier occasion, I had submitted that the time was taken to get the verification from the concerned.
The private respondent cannot be faulted for the delay on the part of the authorities in disposing of the appeal. First of that apart, it is evident that apart it appears from the documents placed on record that the appellate that initially the superintending engineer rejected the prayer of the private respondents for consideration of the online submission of the BOQ generated through online mode, and thereafter the appellate authority took some time to get the documents verified from the credential issuing authority. First up, paragraph merely on the ground that the entire decision on the issue involved could not be taken within the timeline stipulated in point number 15.4, this court is not inclined to interfere with the decision on the part of the authorities in declaring the private respondent as a successful bidder. In declaring the successful bidder, in declaring the private respondent as qualified. Qualified ta inverted comma for me. So stop paragraph. In Michigan, within bracket rubber, Supra, the Honorable Supreme Court held that a court, before interfering in tender or contractual matters, in exercise of power of judicial review, should pose to itself the following question, number one, whether the process adopted or decision made by the authority is malafide or intended to favor someone, semicolon, or whether the process adopted or decision made is so arbitrary and irrational that the court can say, colon, within inverted comma, the decision is such that no responsible authority acting reasonably and in accordance with relevant law would have reached, inverted comma, closed comma, and number 2, Roman 2, whether the public interest is affected. So stop. If the answers to the above questions are in the negative, comma, then there should be no interference under Article 226. First up, in the case on hand, a credential submitted by a party participating in the tender process was verified from the credential issuing authority. First up, adoption of such process cannot be said to be arbitrary or irrational. First up, a decision taken on the basis of the verification done by the authorities from the competent authority cannot be said to be an unreasonable and irrational one. First up, it is not any case of malafide or any biasness or favoritism has been pleaded. Yes, have you pleaded any biasness, favoritism, or
that is, my lord, this is my point, my lord, where is verification?
no? Have you pleaded? Have you pleaded?
My lord, I come not to my knowledge.
Tailor-made to favor the respond number 4.
Tailor-made is
Term.
except certain vague allegation, no specific allegation has been made in this writ petition that the action has been taken by the authorities in order to favor the private respondent. First up, paragraph, it is well settled that it is well settled in Central Coalfields Limited, Supra, the Honorable Supreme Court reiterated the well settled proposition of law that whether a term of NIT is essential or not is a decision taken by the employer, which should be respected. And even if the term is essential, the employer has the inherent authority to deviate from it, provided the deviation is made applicable to all the bidders and potential bidders. First up, if the term is held by the employer to be ancillary or subsidiary, even that decision should be respected. First up, paragraph, in the case on hand, this court has already observed that the authorities have not deviated or departed from the procedures laid down in the NIT. First up, in Jagdish Mandal, Supra, the Honorable Supreme Court held that even when some defect is found in the decision-making process, the court must exercise its discretionary power with under Article 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of a legal point. And the court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. First up, the said decision cannot come to the aid of the petitioner. First up, on the other hand, it supports the case of the private respondent. First up paragraph, for all the reasons as aforesaid, this court is not inclined to interfere with the decision of the appellate authority. Dated 30th of March decision of the appellate authority dated 30th of March 2026, directing the superintending engineer to verify the authenticity of the relevant documents, and the subsequent decision of the superintending engineer declaring the private respondent as qualified, wide order dated 27th of April 2026. Full stop. What is the last document? 20 some May document is there. 21/5, what is that?
Well, this is the memo passed by the superintending engineer. This is the appeal effect they have
Oh,
given. The effect of the-
reconsideration of the bid.
Yes, madam. The effect of the appeal order.
65 is the last one. By page 71 of the decision was communicated to the Honorable Advocate of the petitioner in response to his legal representation.
No, he prayed for again reconsideration.
No, madam. This 21/5.
Page 70.
Madam, this is we asked the department how they disqualified became a qualified. So this is the response from them. Madam, this is the response from the notice on page 66, madam. Page 66 we.
Oh. So this is not relevant. The previous.
No, madam.
Full stop. For all the reasons as aforesaid. Accordingly, the writ petition stands dismissed. Full stop. There shall be, however, no order as to cause urgent photostat certified copy. Thank you. Yes, call the next matter.
For the petitioner, item 42. This is my affidavit of service.
Yes.
My lord, the petitioner is a widow, my lord. Is a widow lady, my lord. The husband of the petitioner was first appointed as Group D staff in Tista Barrage project, my lord, on purely temporary basis. Subsequent, after 3 years, he was given permanent status, my lord. It's at page number 16, P2.
What is the work charge? Work charge like as
Well, kindly come to.
provision for pension or something like that.
Kindly come to page number 16.
No, there is a judgment that a work charge employee is not a permanent, is not entitled to pensionary benefit.
Yes.
Where is that judgment?
That's why I want to learn instruction from this. There's a document stage
16.
Page number
16, 16.
60. Now here it says that the following employees who have completed 3 years service are hereby declared permanent or confirmed. Now I need to clarify what is that. I am otherwise sure that it is a work charge and he will not be entitled to. But how he has been declared as permanent That is something that I need to clarify. And therefore, some instructions are.
It was done in the year 1990, my lord, not very recent matter, my lord. And during his service, my lord,
But if I have a look at the last page of the petition, page 32, therein it is doubted that he was permanent.
Page?
This is a 2023 document. Paragraph 2 says they are seeking for a precedent of granting pension or family pension in work charge employee. As far as my understanding of the work charge cannot claim pension, but then this page is from page 16.
because it's their office order, my lord.
Request for a written instruction come from the authority. And then what we can take it up. Either this or that.
Let a report in the form of an affidavit be filed by
A simple not simple by the executive engineer Mahananda, who happens to be.
by the chief engineer.
I think he was given the executive engineer. Chief engineer was.
Executive
Respondent number
engineer
4.
Mohananda Barrage Division.
Yes, respondent.
Let a report in the form of an affidavit be filed by the executive engineer, Monanda Barrage Division, Irrigation and Waterways Directorate, being the fourth respondent, with regard to the allegations contained in this writ petition, within
And also the status of the inquiry.
report you input within a week from date. First up, petition will be exceptions thereto, if any, be filed by the petitioner within a week thereafter. First up, list this matter under the heading motion immediately after the expiry of the time fixed for filing of the report and the exceptions thereto.
Because it is a pension. Yes.
Obliged, Lordship. Yes, next.
Number 43.
43, Ms. Kushikundo appearing virtually, my lord.
Yes, Your Lordship, I beg to appear virtually in this matter. Lordship, in this matter,
Yes.
my here was to file my appeal, Your Lordship. They have given me the ID password after the filing of the writ petition. So subsequently, I have filed it electronically as well. If Your Lordship may peruse my supplementary affidavit.
Yes, Mr. What do you say?
This is the supplementary
Now,
affidavit.
control is also functional. Previously, what happened was that
Lordship, I
No,
did not-
she wants to file the appeal.
Yes, Your Lordship.
You want to file an appeal before the tribunal?
No, Your Lordship, in front of the appellate authority. I will be using one of my
Before
forums.
the appellate authority. So so now before the tribunal, they have to go before the appellate authority.
No, what I'm saying is all these writ petitions, they are being entertained by my lordship because the tribunal was not functional. Same lord, the status is the tribunal is not functional.
Now, going before the tribunal, then appellate authority, that will be,
Because the period is in
they want only to approach the appellate authority.
Yes, Your Lordship, and heard on merits and my limitation.
So
the
now
bar-
you can file, you can file through online mode now.
Yes, Your Lordship, I've already filed. They have issued a show cause
You have
notice.
filed?
saying- Yes, Your Lordship. They have issued a show
When
cause
have you
notice.
filed?
Lordship, if Your Lordship.
When
may
have you
permit
filed?
my Supplementary affidavit. I filed it right after they have given me the ID password. They have given me the ID password on 1st of July. After that,
Page 7.
Page 7.
page 7
Along
of
with the delay
Lordship, they have issued a show cause notice saying that they will reject my appeal because it's time barred. So I'm seeking for that condonation as well.
So what do you say? Because, no, now I remember for that I've adjourned. Because now they have filed, because according to them, the ID password that was not given, for which they could not file.
Yes, Your
So
Lordship.
if you say I will direct that, that will be considered without going into the point of limitation.
There cannot be a pre-appeal.
The learned advocate appearing for the petitioner submits that the petitioner could not file the appeal. The learned advocate appearing for the petitioner submits that the appeals can only be filed before the appellate authority through online mode. So she submits that since the ID and the password was not supplied to the petitioner, for which the petitioner could not file the appeal through online mode within the stipulated period of limitation. She further submits that, that immediately after the ID and password has been supplied on
Lordship, on 21st of July.
On 21st of July. On
21st of June.
when ID and password.
21st of June.
21st of June.
Yes, Your Lordship.
21st of June 2026. The petitioner has filed the appeal through online mode on
25th of June. 25th of June.
On 25th of June 2026. First up, paragraph. Without that ID and password, they cannot. It is not in dispute that without the ID and the password, online filing of appeals before the appellate authority is not cannot be done. First up, paragraph, considering the fact that the ID and the password was supplied to the petitioner very recently and immediately thereafter, the petitioner has filed the appeal through online mode immediately thereafter, this court, this writ petition is disposed of by directing the appellate authority to consider the appeal filed by the petitioner on 25th of June 20. Any number is there, appeal number?
No. Then they will file it, the number will not be there. The number will get generated subsequently.
All right. Appeal filed by the petitioner against what? Because something has to be there, otherwise.
There is an appeal number. If Your Lordship may take page 8.
There's an appeal number.
Yes, Your Lordship. Page 8
Where
of my
is that?
supplement. Page 8 of my supplement.
Supplementary appeal, page 8.
Lordship, the appeal number.
Mr. Pick up. This is the 80.
Yes.
So there is an appeal number.
Yes.
Filing number.
Appeal wide filing number 8 না এই সাপ্লিমেন্টারি এফিডেভিটের এইটা করে দেবেন এডি এই বিরাট একটা নাম্বার আছে appeal filed by the petitioner on 25th of June 2026 wide filing number বলে এইটা as expeditiously as possible and in accordance with law. So, without dismissing the same on the ground of limitation.
Petition will be given the liberty to protect the cause title. They have criminal revisional jurisdiction. That will be changed.
On the prayer of the learned advocate for the petition, leave is granted to the learned advocate for the petitioner to construction read jurisdiction. What are you?
And in the supplementary affidavit, it is criminal revisional jurisdiction.
To correct the typographical errors in the cause title of the writ petition and the supplementary affidavit, here and now. Full stop.
Grateful.
Yes, next.
44.
আচ্ছা ওইখানে না একটা লাইন রেকর্ড করে দিন হার্ড মিস্টার মিশ্র লার্নেড অ্যাসিস্ট্যান্ট অ্যাডিশনাল অ্যাডভোকেট অন সাচ সাবমিশন পিটিশনের সাবমিশনের পরে একটা লাইন রেকর্ড করে দিন ইয়েস কল দ্য নেক্সট ম্যাটার ইয়েস
Item 44, Your Lordship, I'm praying for next circuit because I have misplaced the service, so I need to serve afresh, Your Lordship.
The petitioner, the learned advocate appearing for the petitioner submits that though the copy of the writ petition was forwarded to the respondents, but the postal slips have been misplaced from the custody of the clerk of the learned advocate. First up paragraph, the petition is directed to serve afresh upon the respondents and file an affidavit of service on the next date. List this matter before the, on the prayer of the learned advocate for the petition, list this matter before the next available circuit bench.
Grateful.
Next.
Grateful, Your Lordship.
Item number 45.
May I beg to appear for the petitioner, my lord. My lord, there has been certain development. This is a matter relating to illegal construction. There has been certain development. Kindly allow me to place a supplementary affidavit.
Filing affidavit in.
I'm supplying them the copy, ma'am.
It's a prayer to allow me 5 minutes only to submit. Because
Please
this
allow
is
me.
not maintainable on the. With 5 minutes only, I mean.
Yes.
My lord, Sudeep Pal, Lord, he is engaged on behalf of SMC, Siliguri Municipal Corporation. His son has become fallen sick and he has gone just, I've been told,
Then
one day accommodation.
on the prayer made on behalf of the learned advocate
Sudeep Pal.
appearing for the Siliguri Municipal Corporation, the hearing of the writ petition stands adjourned for the day.
My lord, kindly, my supplementary affidavit may kindly be taken on record.
Supplementary affidavit filed by the learned advocate for the petitioner is taken on record. And the affidavit in opposition filed by the.
Now
by
we have
the
to
private
file a
respondent.
reply, my lord, to this. We have to file a reply to this affidavit in opposition, my lord.
Then file reply, I'm keeping it in the next circuit.
Or kindly keep it to me.
এরপরে তাহলে একটা রেকর্ড করুন the learned advocate appearing for the petitioner pays for time to file the
My lord, kindly keep it tomorrow, my lord. We'll do it.
affidavit in reply. Full stop. Petitioner will be at liberty to file the affidavit in reply within a week from date. This matter before the next available circuit bench. Yes, next.
Deeply obliged.
My lords, I appear for the petitioner.
Yes.
What is in this matter, Mr. Mishra?
This is a GST case, my lords. Here, I'm challenging the imposition of late fee and the penalty order. Both have been levied for late filing of GSTR 9 as well as 9C returns. Are they taking adjournment, my lords? Should I place my case? Okay.
He will be coming.
He's coming. So, my lords, this is order passed in the year 2023. It was uploaded in View Additional Notices portal. I came to know in June 2026. Thereafter, I approached this court, my lords. There are only two issues which I would like to place. Firstly, whether, my lords, levy under 47(2), because that they have imposed late fee under 47(2), is a single sum which is to be apportioned between CGST and SGST, or a separate sum which has to be charged separately. That is question number one. And question number two is that whether penalty under 125 can be invoked in this case. That's the question which needs to be answered. First, my lords, I will take their circular I'll place, which says that there cannot be separate levy for late fee of 9C and late fee of 9 returns. It has to be one. Here they have charged me two late fees. One, my lords will find the order at page 49 to.
This is not an appealable order.
This is an appealable order, but I came to know now. So it's now become time barred. That's why I've come before
Additional
this court.
notice.
Yes, my lords. But issue is very short. It can be decided.
Issue is very short. That has to. Yes, Mr. Mishra, what do you say? If it is in the additional notice, I give them liberty to file an appeal. File an appeal.
Very well.
So when did you come to know?
On 25/6/2026, page 9, para 13, I have stated.
25/6.
Yes, my lords. 2026.
You came to know.
Yes, my lord.
And when did you file this writ petition?
I filed it immediately thereafter. Filed it on.
Two things. One is
it is affirmed.
I can say that this period will
7
be
July.
excluded, and other is I think if they file within a certain time, decide it on merits. Appellate authority.
We can also say that the merger happened in February.
Yes,
So
yes.
they should have known it by February. Can you also give?
I have explained, my lords, there was a change of
Merger happened in February.
Yes, yes, absolutely.
So if merger happened in February, so your notice was on February, you came to know on February.
No, even then 3 + 1 month time is given, my lords.
So you have that time.
No, till as per my friend, 7th February, the merger happened. I came to know on 25th June.
So he's saying you ought to have known on February.
No, at least from the date of knowledge, 3 months plus 1 month time has to be given to me in terms of the statute. So I'm coming within that time.
7th of June. 3 months for 1 month, 4 months.
June.
Even then, 1 month probation period is there.
New law. A proviso to.
No, 7th of July.
Yes.
So
It was affirmed a week later.
What do you say? So, I giving liberty, how soon can you, so this
I'll
writ
prefer
petition
the-
can be transformed into the form of an appeal?
If they
So
are
you can
willing
file
to-
within 1 week?
I can do that.
Mr. Mishro Lanet, Assistant Additional Advocate General,
Vehemently object.
raises an objection as to the maintainability of this writ petition. So, sir, he submits that the order and the challenge is an appellable order. And for such reason, this court is not in, this court should not entertain this writ petition. First up, faced with such submission, the learned advocate appearing for the petitioner submits that the order under challenge was passed on
2023. 28/12/2023.
order impugned, the adjudication order was passed on 28/12/2023, but the same was uploaded in the additional notices and orders tab, and the petitioner came to know of such adjudication order sometimes in the month of June 2026. First up, he submits that if a week's time is afforded to the petitioner, he can file an appeal before the appellate authority, and the appellate authority be directed to decide the said appeal on merits. First up, it is not in dispute that the order of adjudication was uploaded at the relevant point of time in the additional notices and orders tab, but subsequently there has been merger of the two tabs. Merger of the two tabs. First up, the petitioner states that he came to know of the said order only. How did you come to know?
There was a change of counsel, and then he informed me. In para number 9, I have stated. Page 9, para 13. Page 9, para 13.
The previous council.
Oh, that this merger you came to know after the change of counsel.
No, yes.
Myopic vision, and the new council is very.
Since the petitioner claims that he came to know of the order of adjudication and the merger of the two tabs only after engaging the present advocate on 25th of June 2026, WPA number such and such stands disposed of by granting liberty to the petitioner to approach the appellate authority. First up, if the petitioner files an appeal, there's a format in the
APL
prescribed
04.
format within 7 working days, 7 or 10, within 10 working days from the receipt of the server copy of this order, the appellate authority shall decide the appeal on its merit without dismissing the same on the ground of limitation.
Well, it's just one indulgence.
10 days you can do.
Yes, I can do. This is not an adjudication order, Milord. This is a imposition of late fee order.
আচ্ছা, adjudication না করে order dated এত imposing late fee
Yes,
and penalty also.
and penalty.
Late fee and penalty. Yes.
Next matter is also the same.
Next is
Just
also same.
some dates has to be,
Same new advocate has been
same,
engaged.
same. Because this same party, my lords.
And on the first day of his engagement.
Hmm.
On 24.
27/12/2023 is the order.
Yes.
Order date হচ্ছে 28 এর জায়গা 27/12/2023 and he came to know on
Same, my lords, 25/6.
25/6 ওইটা ঠিক একই আছে।
I'm great.
10 working days.
Yes, yes. I'm grateful, my lords.
Yes, next.
I beg to appear for the petition.
I am for the state being lead by Supriya Singh. I am for the state, my lord, being lead by Supriya Singh.
Yes.
Well, this is a case, my lord, where the petitioner instituted an action before the London Civil Judge Junior Division for and by instituting a suit for declaration, injunction, and consequential relief. Well, the case of the petitioner is the petitioner has purchased land.
Oh, this is that matter, Mr.
Yes,
Dhar?
yes, ma'am.
Lordship, it is a tribal land.
My lord, your lordship.
Absolutely, is a tribal land, and
No.
is a one of the tactics to go grab the
Yes,
land
yes,
of
Mr.
titles.
Dhar, you have considered those judgments.
My lord, your lordship.
Whether an ad interim order of injunction can be implemented. So
By-
police help under section
Well,
151.
kindly appreciate the fact, my lord, what has been pleaded, my lord. What?
I'm asking you,
Obla.
are you aware of those propositions of law?
Well, certain proposition I am aware of.
Whether ad interim order of injunction can be implemented with police help. You obtained an ad interim order of injunction, 1 day prior to the returnable date, you file an application 151, that is allowed
Allow.
without serving.
Without
The
serving.
court says, yes, yes, he is,
Yeah.
he should be aware of that order and passes an order of.
Kindly appreciate the context, my lord. On exceptional circumstances, my lord, the court can invoke
Sir,
the.
if you want, in this writ petition, certain observations I will make. That I'm making it for sure. I've seen the conduct of your client here.
My lord, kindly, for a moment, my lord, kindly allow me
In
to.
this way, ad interim order of injunction cannot be implemented by police help.
Well, the allegation, my lord, kindly appreciate.
Whatever the allegation, fight it in the suit.
My lord,
Who is for the private respondent?
I am the Lordship.
the
Notice has been received.
consequences will be
Notice has
irreversible.
not been given.
Notice
This
has not been given.
No, Lordship, come to the Lordship, come to the page
Who
number
is in
74.
possession?
70, I am in the position.
Ah.
74. And he tried to back me. And this is a tribal land.
He's trying to evict
Tribal land.
you.
That tribal land. This is
Mr. Dhar, have you got that judgment of Halim
This
Sheikh?
this is the judgment.
Yes, please give
This
me.
is the judgment.
Exactly, that was the point which I decided.
My lord's
Well,
judgment.
kindly take
Taking
some-
help of that, he was ousted from the shop room.
Well, kindly take.
That is why I told you that it is, you are trying to take possession, you are not in possession. This shows you are not in possession of that.
Well, kindly takes up page 51, my lord. Well, for a moment, my lord, kindly takes up page 51.
I think you have gone to the facts of this case.
Well,
How the police authorities was used to take over possession from a person who was in possession.
my lord, kindly takes up, my lord, kindly allow me to explain the case, my lord.
All right.
My lord, kindly takes up page
Explain your
51.
case.
My lord, kindly takes up page 51, my lord, for a moment.
Yes.
My lord, this is the ROR of the subject land.
Sir, I'm not deciding your title
No.
possession.
Obla-
I'm not deciding your title possession. I will go to the
Obla-
veracity of the
what
order.
is- what
Please
is-
show me the ad interim order of injunction, whether the tests laid down by the Honorable Supreme Court has been followed while passing an ad interim order of status quo.
My lord,
Please show
that
me.
is at page 53, my lord, order of injunction.
Yes, please show me. Yes, totally unspeaking order, non-speaking order, unreasoned order of injunction.
Well,
One line, having considered the materials, I find he is in possession, prima facie case, balance of convenience. Is it the way of passing an ad interim order of injunction?
well, kindly appreciate, my lord, the factual background, my lord, what has been.
I cannot decide on that factual background, sir.
Well,
Are you
allow me to
supporting this
come back-
interim order of
my lord,
injunction?
allow me to come back with supplementary affidavit, my
No
lord.
supplementary. I am directing, I will request the learned civil judge, they will appear, let them file objection, let it be, I am directing the injunction application to be disposed of, thereafter police help, not now,
My lord,
not now. Please face them.
but we have, my lord, that is why we have
No,
immediately
let
complied
them-
with rule.
Let it be a contested order of injunction. You get a contested order of injunction.
We
you are
have
in
bona
possession.
fidely, my lord, serve them a notice in compliance of rule
No, sir.
3
This order says, again, to serve both ways. Service was not satisfactory. What
Yes,
are you saying?
74 letter.
What are you saying? On
Yes,
19,
They did not file.
That is the plain.
74 is
No.
Please see 74.
Yes, my
74
lord, yes,
page.
my lord.
Yes.
That is, my lord, police report. My lord, before that, my lord.
What police report?
Yes, my lord.
Today is fixed for SR and AD.
Yes, sir.
SR and AD of what?
SR and AD.
Police report. What are you saying?
My lord. Yes, my lord, but we have complied
What
with
yes?
rule.
SR and AD for what? Police report.
No.
Then
I apologize, my lord, but
Then-
we have complied with, my lord, order records, my lord, we have.
please comply. Now they are here. That is why I directed you. Now they are here. What is the next date
My
fixed?
lord, if lordship be pleases to add another request to dispose of the application in terms of order 39 within 30 days. My lord, we are ready for a contested hearing, my lord. Even the order 39 speaks that injunction application has to be disposed of within 30 days. We will be serving Mr. Mahasai the copy of the plaint and
No. I am not the advocate of that court.
Sir, it's
How
very
can
easy.
how
have
can
to
you?
serve there?
Huh.
Copy of the summons.
Summons. It is through
Obliged,
summons.
my lord.
Not in
It is
this
through
way. It
summons.
cannot
Obliged,
be
my lord.
done.
From the date of service of summons, my lord, the non-trial court may kindly be requested to
What is the next date fixed in the trial court?
23rd September 2020.
23rd September. Lord.
By that time, my lord, we will be filing the requisites. My lord, from the date of service, my lord, London trial court may be pleased to dispose of the application within 30 days in terms of the order 39.
In order number? In terms of
Order
13. That is it. Injunction order.
The learned advocate for the private respondent
7.
number 7 appears and submits that the private respondent is in possession of the suit property. Full stop. The petitioner has filed this writ petition praying for issuance of a mandamus commanding the officer in charge of Kranti police station within bracket outpost to provide necessary police assistance to the petitioners for immediate implementation of the ad interim order of injunction dated 27th of January 2026, passed by the learned civil judge, Junior Division, Jalpaiguri. So you have already obtained an order under 151. Why have you approached the writ court thereafter? You have complicated this. After coming to the writ court, you have made this complicated. You have already got the police help. Now with these observations,
this
this
type
order
of-
will be vacated.
Lordship, there. Lordship, this.
What is your report? দেখান তো দেখি আবার কি যায়। Yes, what is your report?
Report কি?
Malad, the investigation officer filed a non-FIR, PR number 113 of 2026, dated 27/2/2026, 2026, my lord. And my lord, kindly see the next page of the report, my lord, third para. After during inquiry, it was found that the respondent is complying with the injunction order and no interference with the dispute land has been noticed, my lord. No, this is civil in nature, my lord. They already filed a declaration suit, my lord.
Full stop. Record reveals that the petitioner filed title suit number 38 of 2026 on January 22, 2026 and filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, praying for temporary injunction. First up, the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure was moved by the petitioner on 27th of January 2026, and an ad interim order of injunction was sought for by the petitioner. First up, the learned trial judge, by an order dated 27th of January 2026, allowed the prayer for ad interim injunction restraining the defendant, that is the respondent number 7 herein, and their main agents from entering and disturbing the peaceful possession of the petitioner in the suit land till 20th of March 2026. First up, on a day prior to the returnable date, that is on 19th of March 2026, the petitioner filed a put-up petition for urgent hearing of the application under Section 151 of the Code of Civil Procedure. First up, the put-up petition was allowed and the application under Section 151 of the Code of Civil Procedure was taken up for hearing on 19th of March 2026, and the same was allowed by directing the officer in charge of Kranti Police Station to provide necessary police assistance to the plaintiff/petitioner hearing for implementation of the ad interim order of injunction dated 27th of January 2026. After going through the order dated 19th of March 2026, this court finds that the learned trial judge recorded that the provisions under Order 39, Rule 3 within bracket small a and 3 within bracket small b were complied with by the petitioner, and the affidavit of compliance was filed. First up, the learned trial judge accordingly was of the view that the defendant, that is the private respondent number 7 herein, where has the knowledge of the restraint order passed by this court. First up. However, from the order dated 20th of March 2026, this court finds that the petitioner was directed to file fresh requisites through both ways. Full stop. And 22nd, full stop, and 22nd of June, 2026 was fixed for service returns. Full stop. The learned trial judge, by an order dated 22nd of June, 2026, recorded a specific finding that from the record it appears that the earlier orders have not been complied with. Full stop. Petitioner was directed to comply with the order dated 19th of March 2026 at once, and he was directed to furnish the copy of the plain and the order. Full stop. The petitioner was directed to file fresh requisites through both ways at once. So this was a very good ground for vacating of your ad interim order of injunction. Sir, that's a very good ground. It could not have been extended. Could not have been extended. If you have failed to comply, sir, what are you saying?
We have, my lord, 3A3B has been complied. 3A3B on the letterhead of the concerned advocate, my lord, it is being sent immediately on the day after.
Court records, you have not complied.
That is the requisite part, my lord, the summons part. Yes, my lord, it records, my lord, we have not complied.
Then that's the ground for vacating the ad interim order of injunction.
But my lord, 3A3B was duly complied.
Sir, what are you saying, 3A3B? The court records. How can it extend at the same time? That is why I asked you not to invite this court. These observations are to be made now here. Full stop. The first question that arises for consideration is whether an ad interim order of injunction full stop. This court refrains from making any observation as to the propriety of the orders passed in the suit sitting under Article 226 of the Constitution of India. Full stop. The petitioner claims to be in possession of the property in question and relies upon an ad interim order of injunction passed by the learned trial judge. Full stop. Record reveals that the order of injunction has not been served upon the respondent number 7. Full stop. The learned advocate for the respondent number 7 submits that the 7th respondent is in possession of the property in question. Full stop. It appears from the submissions made by the learned advocates for the respective parties that there is a serious dispute as to possession in respect of the property, which is the subject matter of the civil suit. Full stop. For such reason, this court is not inclined to pass any orders, to pass any further order, to pass any further direction upon the police authority. Full stop. WPA number such and such accordingly stands disposed of. Full stop. The petitioner and the private respondents will be free to take appropriate steps in accordance with law before the learned trial judge. The only thing is that private respondents now became aware of the now take us as an actor line. The learned advocate for the state files the copy of the report of the officer in charge, Kranti Police Station, Malbazar PS, dated 18th of July 2026, which is taken on record. Kranti Kranti Outpost. Kranti Outpost, Malbajar Police Station, dated 18th of July 2026, which is taken on record. First of the said report states that the dispute is civil in nature and a civil suit is pending.
Grateful.
Yes, sir. Take the copy of the judgment.
Yes, sir.
Not you. You search it out.
No,
Hey,
no.
It was given by the state.
Oh, given by the state. Oh, return it to the state. Yes, yes.
Item number 49.
I am for the state, my lord.
My lord, I am
You are led
appealing
by?
for the petitioner, my lord. I am appealing for the
Yes.
petitioner online, my lord. Yes, my lord. This is the case. That is, this writ petition has been preferred by the petitioner, my lord, due to the inaction on the part of the police authority. My lord, what
My
happened?
lord,
that-
FIR has been registered.
FIR has been registered. No,
Yes, my lord. Yes.
it's under investigation. Complete
Yes,
the
yes.
investigation.
Yes,
The
yes. May I
the
go on
petitioner
humble
alleges.
indulgence, my lord?
Yes.
My lord, report
Yes,
may be
what do you
handed
say?
over to my learned. Report
It's
may be
not a
handed over
report,
to my
instruction.
learned.
I'll give the details of the FIR, my lord. I'll give the details of the FIR.
Please give the details of the FIR.
Great,
Uh,
great.
the petitioner alleges
No.
that the police
It-
authorities have not taken
Yes.
any steps to register a first information report in spite of a complaint being lodged by the petitioner disclosing cognizable offense.
What are you doing here?
First up, Mr. Bhattacharjee, learned additional government pleader submits that an FIR has already been registered. First up, you have given the particulars.
I'm giving my lord.
The particulars of the first information report has been supplied to the learned advocate for the petitioner in course of hearing of this writ petition. Mr. Bhattacharjee further submits that the investigation is in progress. First up, in the light of the submissions made by the learned advocate to the respective parties, WPA number such and such stands disposed of by directing the concerned investigating officer to complete the investigation as expeditiously as possible.
Grateful, my lord. I'm handing over the details, my lord.
And to take all consequential steps thereafter. Yes, next.
My lord, here, lordship, I'm praying for 1 day. Kindly take it on Wednesday. There was a direction to file a report. Report has come. The report says that certain documents are annexed to the report, but the documents are not there. The report was handed over to me today morning, my lord.
When do you want?
Tomorrow, because my
Mr. Bhattacharjee, when do you want?
after tomorrow, today I'll tell you.
On the prayer of Mr. Bhattacharjee, learned additional government pleader, list this matter.
Wednesday or Thursday, as per your lordship's convenience.
Wednesday, I'm keeping.
What, my lord?
29th.
Great.
Yes. Yes, call the next matter. Yes.
I'm appealing for the petitioner.
My lord,
My senior is
My lord, I'm
Actually,
for the
yes.
petitioner, my lord. My lord, I'm appearing virtually. My lord, today
Yes,
the
yes.
respondents are supposed to submit.
Yes, yes, Mr. Mishra.
Yes, my lords.
How long you will take?
The destiny has tuned the clock in such a way that this matter always appears at 4:25.
4:15, 4:25, something like that. I'm making it not today because today I have to rise a bit early. Not today. Yes, next. Next, call the next matter.
My lord, only one indulgence, my lord. Let the matter may be fixed at top of the list, my lord, if your lordship allows.
Because this is a contested matter, it has to be hard. Let me see. Yes, next. 52. Yes.
Lord, I am for the petitioner, my lord.
Yes.
My lord, this is that matter your lordship recalls. CPF to GPF, son is seeking the ADR pension, my lord. I have submitted the order sheet, my lord. Order of this coordinate bench, my lord.
Where is that?
My lord.
Yes, Mr. Ghosh.
Now, although my instruction yet not received, my lord, but
My lord, on the last occasion also, learned friend sought for instructions, my lord.
Where is your application? No, you have deposited the amount.
Yes. By way of a PR Form 7 Chalan, my lord. I have annexed in the petition, my lord. Similar order may be passed, my lord.
Where is your application?
My lord, page 17 is my option, my lord. Page 17 annexed P2 from switching over from GPF to CPF, my lord. My lord, thereafter, my lord, page 18 is my refund.
You are the teacher or
My mother was the teacher. Subsequently, mother expired. Thereafter, my father also expired.
yes?
And my lord, moreover, my lord, my younger brother had given me no objection, my lord. I have annexed the no objection certificate in the report.
So you have applied for option.
Yes. No, my father has applied.
Your father has passed.
Mother has applied. Manjusri Roy Dasgupta, my mother.
Now you will be only entitled to that area amount.
Yes, only entitled from the date of retirement.
This is not the only that area amount. This is for the
From the date of retirement to the date of refunded only, my lord. Date of retirement to date of refunded. That only that area I am claiming, my lord.
the
one thing, my lord, the brother is not made the has not made the is not the petition before lordship. The brother portion is also be taken care of, my lord.
My lord, no objection is given, my lord.
No objection is given, my lord.
Page 26, paragraph 5, my lord.
The area pension, my lord. According to petitioner, both are legal here.
Yes.
yes.
So younger brother has given me no objection.
Have you implemented him? No.
No.
Yes. What do you say? But one brother has given his no objection.
No objection has been given, my lord, before as a petition filed before your lordship, my lord. But both are, my lord, the joint. Both are the legal heir, my lord.
Yes.
Yes,
But if one gives consent or no objection to
that,
the other,
that portion will be dealt by the consent department according to my request.
that will be decided by the department.
Yes, my lord.
Yes.
Yes, my lord.
That I am making.
My lord, he stays in Delhi. He has to come back from Delhi, my lord, for this. My lord, already issued.
No, you produce that document.
My lord, this document I have annexed.
Let the authorities, or I will direct the report to be filed. Let them verify.
Verify this affidavit. I'll produce the
That
original.
they will do.
I'll produce the original. Not personal appearance. He has to come down.
Virtual, it can be done nowadays. No
Then
problem,
my lord
Mr.
gives
Dar. No problem nowadays. Virtual appearance is also permissible.
So my lord shall direct, my lord.
If I direct that, then you have to appear to virtual mode. I have no difficulty. If you say that, I can direct, they will conduct virtual. There will be difficulty if brother says something. The evidence service filed in court today.
Law is well settled, my lord. On top of that, judgment is also there.
What well settled?
My lord, that I am entitled to get the area pension amount.
Depriving the other brother.
No.
That is the only issue.
Yes, my lord.
That is the only issue. He says that they will consider that. He is not saying that he will not be getting.
Yes, my lord.
He is saying both of you are entitled. He is willing to give to both of you and you want to grab the entirety. That's the problem. There lies the problem. Affidavit service filed in court today is taken on record. The mother of the petitioner was a primary school teacher.
Yes, assistant teacher.
Assistant teacher of a high school. The mother of the petitioner was an assistant teacher of a
High school.
high school or a higher secondary school.
Higher secondary school.
Of a higher secondary school. Full stop. The Nadina, who retired from service on superannuation on 1/6/2004. Full stop. The mother of the petitioner retired from service under the retired from service. At the time of retirement, the mother of the petitioner enjoyed the benefits of contributory provident fund cum gratuity. Full stop. The petitioner claims that the mother of the petitioner applied for exercise her option to switch over to the GPF scheme from the mother has approached.
Yes, yes.
Switch over to the GPF scheme from the CPF scheme upon refund of the employer's share of provident fund. To stop, the petitioner, being one of the son of the deceased teacher, intends to avail the benefit of the government order being number 749-SE capital within bracket L/SL/56/13/P capital T small dash Roman 5 bracket close dated 13th of June 2014, pursuant to which the teachers had the option to join CPF scheme upon refund of the employer's share of the provident fund. Full stop. The learned advocate appearing for the petitioner places reliance upon an order dated 19/12/2025 passed by a coordinate bench in WPA 2503 of 2025 in support of his contention that under similar circumstances, the coordinate bench allowed the petitioner therein to the benefits of area pension and family pension from the date of death of the employee. Full stop. Paragraph. The petitioner is not entitled, the petitioner being the son, is not entitled to the family pension, but he shall be entitled to the area family pension, which may be due to the deceased teacher. In accordance with the said notification. First of paragraph, WPA number such and such stands disposed of by directing the district inspector of schools within bracket secondary education, district inspector of schools within bracket is secondary education, Alipurduar being the fifth respondent, to process the application filed by the petitioner as expeditiously as possible. Full stop. When have you refunded?
Milord, refunded on Milord, 2nd September 2014, Milord.
The learned advocate appearing for the petitioner submits that the Employees Provident Fund, together with interest and additional interest, has already been deposited by the petitioner on 2nd of
September 2014,
on 2nd of September 2014.
page 18.
First of paragraph, the কত number respondent? The fifth respondent is directed to process the application of the petitioner, and if all formalities have been complied with, pension payment order shall be issued in favor of the petitioner within 6 weeks from the receipt of a server copy of this order. First step, since the deceased teacher left behind 2 sons and the petitioner is one of these 2 sons, it will be open to the 5th respondent to consider the issue of entitlement of the area pension, to consider the issue of the petitioner's entitlement to the area pension in accordance with law. Full stop. It will be open to the petitioner to place relevant materials before the 5th respondent. If the 5th respondent directs the petitioner to produce materials, full stop. In the event the 5th respond, full stop. Anything more?
Milord, instead of secondary education, it will be HS, Milord.
I've said HS. No, not HS. It's secondary education, AC.
AC.
DIAC, not HS.
No, I'm grateful.
With your lordships, kindly, item 53 was specially fixed today. Would it be possible to keep it tomorrow in the first term?
Tomorrow there's a division bench, 2 p.m.
My lord, he is coming there physically, my lord. My lord, he is come there physically to do this matter, my lord. That is the only difficulty.
My lord, it doesn't.
But there's a division bench. I did not know. There's a division bench.
I understand, my
tomorrow
lord.
at
If
6.
my lord may take the
After
matter
that,
today.
Today it's not possible, madam.
Small indulgence,
Affidavit of service.
Affidavit of service. Is a matter. 74 or 76.